Good morning, colleagues. Can anybody hear us? Morning. Good morning. There's a French interpreter. There's a Portuguese. Don't know who is this one. Maybe we need to go in that side.
Bongi.
Don't stress, I'm just gonna see them. Okay. So,
What's the hold up now? Yeah. Thank you. Ladies and gentlemen, will you please rise for the Chief Justice of the Republic of South Africa and the Minister of Justice and the Speaker of National Assembly and Minister of Women and Children and Disabilities. Thank you. I think there will be enough space for everyone. Yeah. Hello, Minister. Hello, Minister. How are you? Thank you. Will you please remain standing for the singing of the national anthem of the Republic of South Africa and the AU anthem. Thank you. Thank you. You may be seated. Good morning, bonjour, bon dia, assalamu alaikum. Good morning, esteemed guests, colleagues, partners, ladies and gentlemen. My name is Nonkosi Nhlanhla. I'm a judge of the Constitutional Court of South Africa. We thank you all for your attendance, and a special thanks to those who traveled from afar to attend this important meeting. It is my privilege and a great honor and pleasure on behalf of the Chief Justice of the Republic of South Africa, Chief Justice Mandisa Muriel Lindelwa Maya, to welcome you all here today. Our Parliament is represented by the Speaker of the National Assembly, the Honorable Ms. Thoko Titiza, and the Executive by the Minister of Justice and Constitutional Development, the Honorable Ms. Mamuluko Kubai. Among our esteemed guests, we also have the presence of the Minister of Women, Children, and Persons with Disabilities, the Honorable Ms. Sindisiwe Lydia Chikunga. We are grateful for their presence. The second high-level meeting of women judicial leaders is hosted by the South African Judiciary, led by the Chief Justice Maya, in collaboration with the Conference of Constitutional Jurisdictions of Africa, normally called the CCJA, and it's represented here today by the Secretary General. The CCJA is an independent body that consists of Supreme Courts and constitutional jurisdictions in Africa and plays a role in promoting constitutionalism, strengthening the rule of law, and safeguarding the integrity of democratic institutions with member states. This meeting is attended by women leaders and delegates from 23 jurisdictions across CCJA member states, and these are the People's Democratic Republic of Algeria, Republic of Angola, Republic of Burkina Faso, Republic of Burundi, Republic of Chad, the Union of Comoros, Democratic Republic of Congo, Arab Republic of Egypt, Kingdom of Eswatini, Republic of Gabon, Republic of Gambia, Republic of Liberia, Republic of Madagascar, Republic of Malawi, Republic of Mali, Republic of Mozambique, Republic of Namibia, the Federal Republic of Nigeria, Sahrawi Arab Democratic Republic, Republic of Senegal, Republic of Sierra Leone, Republic of Zambia, and Republic of Zimbabwe. I also acknowledge the virtual attendance of Lady Chief Justice Carr of England and Wales, who will attend this opening ceremony in part. The other participants during our proceedings include a representative from the African Court on Human Rights and People's Rights, specialized regional legal experts and academics, representatives from partner organizations, including the United Nations Development Program, the United Nations Organization on Drugs and Crime, the United Nations Educational and Scientific Cultural Organization, that is the UNESCO, and the Arab Women Judges Network. We also have observers from civil society organizations working on women's rights and access to justice. Allow me to also extend a sincere word of gratitude to our sponsors, JUTA, PPS, and the South African Tourism. I invite the delegates to visit their exhibition tables. We also brought a taste of South African creativity, sponsored by the South African Tourism. I invite you to spend some time at their stalls and see the expression of our diversity. This meeting aims to build upon the foundational dialogues and networks established during the inaugural meeting, which was held in Libreville, Gabon, on the 2nd and 3rd of May 2023. Taking a step forward in strengthening the role of women judicial officers in advancing constitutional justice and gender equality across the African continent. The theme of this meeting is the Maputo Protocol, at 20 years, consolidating the jurisprudence of equality for the next generation. The meeting of African women judges aligns with the commitments of the United Nations and the African Union regarding women's rights and gender equality. These commitments are reflected in key documents such as the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the Convention on the Elimination of All Forms of Discrimination Against Women, the African Charter on Human and People's Rights, the Maputo Protocol, the Arab Charter on Human Rights, and various other initiatives, such as the African Union's Agenda 2063 and the 2030 Agenda for Sustainable Development. This meeting is strategically timed to coincide with three momentous occasions, namely the 20th anniversary of the protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa, the Maputo Protocol, a landmark regional and human rights instrument providing comprehensive binding framework, promoting and protecting the rights of women in Africa, responding to historical and structural discrimination through transformative legal and policy obligation. It also coincides with the 30th anniversary of the Constitution of the Republic of South Africa, a transformative document globally celebrated for its progressive Bill of Rights and unwavering commitment to equality, dignity, and freedom. Furthermore, it coincides with the 70th anniversary of the 1956 Women's March to the Union Buildings, a pivotal event in history in South Africa, where an estimated 20,000 women courageously protested against apartheid pass laws, embodying the resilience and power of women's collective action. The advancement of women within the judiciary worldwide represents a crucial frontier in the journey toward gender equality. Their presence on the bench is not merely symbolic, it is fundamental to the legitimacy, quality, fairness of judicial systems. A diverse judiciary, inclusive of women, incorporates a wider array of perspectives and life experiences, enriching illegal interpretation and ensuring that the law evolves to serve all members of society justly. From lower courts to Supreme and constitutional benches and international tribunals, women jurists are increasingly presiding over cases, authoring landmark judgments or opinions, and challenging patriarchal legal norms, thereby strengthening the rule of law and providing powerful role models for future generations. Despite this progress, significant disparities persist. In many nations, women remain severely underrepresented in the high judicial office and leadership positions, facing barriers such as unconscious bias in appointments, lack of mentorship, and entrenched institutional cultures. Ensuring equal participation of women in the judiciary is essential for upholding the fundamental right to a fair trial and for building public trust that the courts truly understand and represent the societies they are sworn to serve. This meeting provides a unique platform to reflect, consolidate, and strategize for the future, and is intended to integrate networks, deepen cooperation among women judicial officers, and strengthen collective efforts to advance constitutionalism, judicial leadership, and gender equality on the African continent. Despite significant legal and constitutional advancement across Africa, women and girls continue to face pervasive discrimination, violence, and socioeconomic marginalization. The gap between the fundamental rights enshrined in instruments like the Maputo Protocol and national constitutions and the lived reality for millions of African women remains stark. The judiciary, particularly the constitutional and Supreme Courts, serve as the ultimate guardians of these rights. Women judges bring critical perspectives, lived experiences, and a nuanced understanding of gender-based discrimination to the bench. Their empowered presence and leadership are essential to interpreting laws through a gender-sensitive lens, developing a robust African jurisprudence on equality, ensuring effective implementation of the Maputo Protocol and similar national laws, and enhancing public confidence in the judiciary's commitment to justice for all. Therefore, this meeting seeks to address the need for continued peer learning, strategic collaboration, and capacity building among Africa's leading women jurists to bring the implementation gap and accelerate the progress. The objectives of these meetings are that the high-level meeting is a strategic convergence point to honor the past, evaluate the present, and judicially shape a more equitable future for all African women and girls. The primary objective of the meeting is to empower women judicial officers to be catalysts for transformative jurisprudence on gender equality and in Africa. The specific objectives include to critically analyze the impact of the Maputo Protocol over the past 2 decades through the lens of land-backed judicial decisions, to foster peer-to-peer exchange on overcoming procedural and substantive barriers in adjudicating cases involving women's rights and uphold the rights and dignity of all people, to develop strategies for leveraging constitutional provisions such as those in the South African Constitution to advance the principles of the Maputo Protocol at a national level, to strengthen the network of African women judicial officers in strategic partner countries, including through a dedicated platform anchored by a sustainable monitoring and evaluation framework of these meetings, to formulate a clear action plan that may be termed the Johannesburg Declaration for the CCJA network of women judicial officers, outlining commitments for the next 5 years. All of this will be done under the following topics. From Libreville to Johannesburg, we will commence by reviewing the progress made and lessons learned. In this regard, the Secretary General of the CCJA will provide a report. Session 2, advocating violence against women, interpreting laws on domestic violence, femicide, and harmful practices. Session 3, economic justice and empowerment landmark rulings on women's rights to property, inheritance, and financial inclusion. Session 4, sustainable environment, participation and representation. The judiciary's role in ensuring that women live in a healthy environment. Session 5, the digital frontier, addressing technology and ensuring digital rights for women. Session 6, an interactive session when the Chief Justices and the Presidents of the Apex Courts will share their experience and challenges. And what do we expect out of this meeting? We expect a strengthened and active Pan-African network of women judicial officers committed to gender-sensitive adjudication, a published compendium of leading judgments on the Maputo Protocol from across Africa, a forward-looking declaration and plan of action for the CCJA on women, justice, and gender equality, and an enhanced judicial capacity and shared strategies for dealing with complex women's rights cases, and increased visibility of the CCJA's work in promoting gender equality within the judiciary. During this plenary session, messages of support will be shared, and the Chief Justice Maya will deliver the keynote address. I hope that you will find these days both inspiring and productive. Thank you. Now I move to the next stage of my session to invite the speakers that will be sharing words of support and addressing us today. And the first speaker, and I must excuse the pun, is the Speaker of National Assembly, who will share a message of support. Thank you.
Good morning. Bonjour. Sanbonani. Molweni. Salam alaikum. Thank you very much, Program Director, Justice Nkosi Mhlahla, Chief Justice in the Republic of South Africa, Mandisa Maya, Minister of Justice and Constitutional Development, Honorable Kubai, Minister of Women in South Africa, Honorable Chikunga, Our Lady Justice of the African Court on Human and People's Rights, Honorable Chafika Bensa Ula, you'll forgive me if I've not pronounced your surname correctly, women members of the Judiciary in South Africa, and the justices that are here from all over our continent and abroad. I understand one of them is joining us online from the UK. Ladies and gentlemen, it is indeed my utmost pleasure and privilege to join the distinguished women jurists and guests in this second meeting of women leaders in African judiciary. I'm delighted that this meeting is held in our soil at the same time when our country commemorates its 30th anniversary of the Constitution. One of the critical architectural elements of our Constitution is the Equality Clause. It guarantees equal protection of the law and prohibits unfair discrimination on the grounds of race, gender, and other aspects of life. This reminds me that actually the fight for the Equality Clause in our Constitution did not only start during the negotiations for a democratic dispensation. It started in 1954, when the South African Federation of Women developed the Women's Charter. At the time, one of the things that they talked about was a single society, where they said there is no society for women. Society is composed of both men and women. The issues that affect men equally affect women. The concerns, the hopes that men share are equally shared by women. In that very document, they talked of the Equality Clause. They reflected on what were the challenges that took women as subservient to their husbands, but also to their masters. It is these women and many that followed that we celebrate today. It is the women who form the African Organization of Women in 1962. Again, trailblazers who understood the importance of unity in struggle in order to create a better Africa. Most of the people always remember African unity through the formation of the African Organization. When they remember the OAU, the Organization of African Unity, which was formed in 1963, they forget that it was women in 1962 that actually formed the first continental body that looked at how we could deal with the challenges that Africa faced. Again, in our country, it was in 1954 that women came together from all walks of life to form the South African Women's Federation. And most of the clauses that you find in the Freedom Charter that was later agreed to by everybody in 1955, it picks from a number of those principles that women in 1954 articulated. I'm raising this, Program Director and our honorable judges from across our continent and beyond, because it is important to appreciate the power that women have when they come together to reflect and chart the way forward. Today, the inclusion of the Equality Clause in our own Constitution was just not symbolic, but it was sacrosanct. It was a commitment that meant we needed to reform our laws and practices and entrench this principle in our government programs and priorities. But maybe, if I were to digress a little bit, just to share the journey of how that Equality Clause came to our Constitution, it was not just those who were negotiating who had bright minds and thought, yeah, we must have this constitutional provision. It was through struggle. In 1992, South African women came together from all walks of life, different professions, different races, different cultures, religious, and so on. Together they said, we want to input on the South Africa that must be for all of us and our children. And one of the things they decided was, we will change the landscape of the negotiators. Some of you, if you were to go back into the archives, you'll remember that the first CODESA meeting, it was all men in gray suits and black suits and maybe navy. And they all looked very serious, negotiators. And many women who were actually intellectually competent were more your support staff behind drafting documents, moving documents around. And the Women's National Coalition said that will never happen under our watch. So we marched to the World Trade Center where the negotiations took place and say nothing about us without us. Well, we didn't storm the venue, but we raised our voices, and when the negotiations continued after the Boy Patong massacre, it was men and a woman on the table. But we also said, being on the table, it's one thing, but it's what we put in that table for debate and dialogue, and finally, in the Constitution. And that's when the Equality Clause came through. And we said, yeah, the clause is important, but how do we safeguard that clause and make sure that it's operationalized? We said there must be a structure in the Constitution that continuously monitors how, as a country, we're faring on issues of gender equality. And that's why, even today, one of the Chapter 9 institutions is the Gender Commission. So it didn't come through a plate. It was through struggles. But the permeation of that struggle of women was to make sure that we also operationalize that indeed in all spheres of life, women are not just heard, or seen, but their presence is felt. It was for that reason that, among others, the former Minister of Justice then, Minister Justice Mabandla, started the Aspirant Judges Program, where deliberately was to say, how do we make sure that we enable and prepare women to actually become part of the judiciary? But beyond the aspirant program for the judges, it was about how those who have been put in the Judicial Services Commission that appoint judges, even though we're not many in these structures, but those women who were there were very deliberate that in the selection of judges, we will make sure that women are part of that. If it means going out and advising some of our advocates to make themselves available for those appointments, we shall do so. If it means enabling some of our women to make themselves available to be acting judges, that shall be done in order to ensure that it is not by accident, but it is being deliberate and determined. And I'm happy today that the fruits of the commitment that those women have been reflected in our judiciary. As you see, our Chief Justice, the first in South Africa, Justice Maya, is a woman. Our program director, another judge in the Constitutional Court, also a woman. Actually, today, I can count many, not just in the Constitutional Court, not in the Supreme Court, not in the High Court, but also in the magistracy, where a majority of women access justice. Women are there. It is through the commitment of those women and those that came after them, ensured that even in the academia, we continue to ensure that women do access the legal fraternity, because without continuously growing that cohort of women in law who will finally become part of the judiciary, we would not have concluded our journey. Today, our Constitutional Court and other courts have helped us to better understand and uphold the equality commitment through several judgments. Because some people may ask, so once these judges who are women are appointed, how will they change the landscape? How will they make sure that indeed this equality clause is realized? And in my view, when women sit in that big chair, because it's always big, they don't only look at the case and the legal argument. I believe there's a gender perspective that you bring in also assessing the matters that are before you. So that when you look at our statutes and its provision, you are indeed able to say you will advance the equality commitment that we have all agreed to. Just want to make an example of one of our judgments that was meted out by our courts. Relating to inheritance rights, regardless of the gender or birth or status of a child. This judgment affirmed the right of girls and women to succeed even in traditional leadership position, which was unheard of before. Addressing the Women's Day event last year, President Cyril Ramaphosa reminded us that women's rights are inseparable from human rights, which I agree with, and I'm sure all of you do. Our commitment to women's rights needs to evolve from the mere commitment to concrete and lived realities for women in our country, in our continent, and beyond. These are the same principles that guided the Maputo Protocol adopted in 2003. As our program director indicated to us what then Maputo Protocol reflected on and what commitments were made. And I think it is incumbent to all of us seated here as we evaluate the 20 years of having had that Maputo Protocol, we must earnestly ask ourselves, how far have we gone as countries? How have we ensured that in the work that we do, not only just as the judiciary, but also as the legislatures, created mechanisms that would allow for women's rights to thrive across our continents? How do we ensure as legislators that in the laws that we draft, we are conscious of how women's rights can be attained but also protected? And I think it is when matters come to court that what we do as lawmakers also get tested. Whether indeed in the development of those statutes, we have ensured that we take into consideration what our Constitution and other protocols that were signed are actually taken into consideration. Program Director, through the work of Parliament, which is also oversight, we do look at how far our executives have gone in actually ensuring that women can attain their rights, but also continuously change our society for the better for women and girls. But also as part of our parliamentary diplomacy, we form part of the South African Development Community Parliamentary Forum. We are also part of the Pan-African Parliament, and globally we're part of the Commonwealth, and we are also part of the Interparliamentary Union. Again, in all of this, one of the issues that we look at is how, as these institutions, can ensure that we create a better space for women at all levels. It is not also about creating a better space, but it is also about how we utilize the energies that women in these various spaces, particularly in the judiciary, can help in improving our society for the better. We all can attest that in some of our countries, constitutional courts have relied on the Maputo Protocol to end educational discrimination, particularly against pregnant schoolgirls, as well as to combat child marriages. In some of our regions, our courts, and indeed led by women, have ensured that the protocol has assisted in ending the female genital mutilation. And I think one of the issues we need to ask ourselves, given where we are as the judiciary, how do we ensure that time and again we interface with women in civil society, so that some of the issues that we have to grapple with, they can understand them better? For instance, there are situations where your judgments, are good, but sometimes we do not understand and wonder, this was a woman judge. How does she give such a minuscule sentence for this gentleman who has done such an atrocious act? At times we even forget that there are lawyers who have to argue for and against. And when we sit there, we say, yeah. And I think it is at these moments where sometimes conversations outside of the courts become important. Similarly, as legislators, there are moments where we wonder, why has this legislation been brought back when we think we had done everything under the sun? And then our learned judges will say, well, there was not enough public participation. I said, okay, what's the measure? You've got 60 million people. So what's the threshold for adequate consultation? And again, for me, it's an area which may require some conversation with one another as lawmakers and those of you in the judiciary to help us better understand what it is that we need to improve so that the statutes that indeed we draft can actually go through, if tested, meet the test. Program Director, honorable judges, central to the efforts of attaining the goals of the Maputo Protocol is a strong and evolving parliamentary oversight architect. Parliaments across the continent, in my view, should put in place mechanisms to ensure that parliaments can hold those in government to account without fear or favor. Moreover, protecting the independence of the judiciary and safeguarding the safety of our jurists in performing their constitutional duty is paramount. I'm happy that in your program, you have also you are going to be reflecting rather on the issue of wellness and mental health of women jurists. Whilst this meeting will focus on sharing experiences and forging collaboration in the implementation of the Maputo Protocol on women's rights across the continent, I'm particularly pleased that pertinent issues affecting women in the judiciary itself are not left behind. Issues affecting women's wellness, safety, and emotional burden in the judicial service are increasingly recognized as collective institutional responsibility rather than just a personal struggle for individual jurists. As women judges, you continue to face a double burden of balancing high-stake decision-making with entrenched social and family expectation, consequently leading to elevated health risk and burnout. That you are judges does not stop that unguma. When you come home, the children will still say, Mom, food, Mom, at school, Mom, my soccer boot is missing. And you are thinking, oh my God, I have to craft this judgment. If you've got a husband who sometimes become our firstborns, you come and says, does not even say judge now at home. Maka so and so, where's the food? Yeah. So those struggles still continue. They don't end because you are in the judiciary. And we expect you to excel despite. So how do we support one another conscious of these realities? How do we make sure that it does not become a burden that pulls many of young people to aspire to be in the bench? Program Director, Chief Justice, and our judiciary, one of the challenges that we face today is how do we navigate around the issues of conflict in our continent, but also globally. How do we ensure that justice, even in those issues that are as a result of conflict that come across us, are attended to? and particularly with special focus on women and girls. But also, we are in a country and in the world that's evolving in terms of technology. At times you will see on TikTok something said about you and it's not you. So the issues of cybersecurity, stolen identity, how do we navigate them when it comes now across us, when some of those can clearly be seen by others as authentic when they are not? So we are not 20 years ago when we went to Maputo. We are in a different society today, where we still have to address the issues of justice in this changing world. I want to congratulate you, Justice Maya, and your team for having been the host of this conference. And I hope you will be able to execute your task and attain the objectives that you have set for yourselves. From me to you, all the best.
Thank you very much, Madam Speaker, for the moving and inspiring speech. Our next speaker is our own Minister of Justice. She'll provide an address. That is Ma'am Mamuluko Kubai. Thank you.
Thank you very much, Program Director, Justice Nonkosi Nhlanhla of the Constitutional Court. Acknowledgement of the Chief Justice of the Constitutional Court, Chief Justice of South Africa, Chief Justice Mandisa Maya. Acknowledgement, pardon me, my voice is still battling. Acknowledgement of Honorable Speaker of Parliament of South Africa, Ms. Thokoti Diza. Acknowledgement of the Minister in the Presidency responsible for women, youth, people, and people with disability, Honorable Sindisiwe Chikunga. Acknowledgement of the Honorable Lady Justice Shafika Ben-Saula, the African Court on Human and People's Rights, justices and delegates from various member states, distinguished guests, good morning. It is indeed a pleasure and privilege for me to join you this morning in this very important gathering that brings together women judicial leaders from across the African continent. The focus of this gathering on strengthening gender-focused jurisprudence, enhancing judicial leadership, and ensuring a more inclusive and representative justice system is timely and necessary. Any gathering that concerns itself with emancipation and advancement of women in any sphere of society deserves all our support and our praises. This is the struggle for women emancipation from the clutches of patriarchy that has been long and painful, but continues to live with us. This meeting coincides with a significant milestone, which includes the 20th anniversary of the Protocol of the African Charter on Human and People's Rights, on the Rights of Women, also known as the Maputo Protocol, but our own inner country, the 30th anniversary of the South African Constitution when it was adopted by Parliament, passed by Parliament and signed into law by President Nelson Mandela, and the 60th anniversary of the 1956 Women's March to the Union Building in Pretoria, led by icons like Lillian Ngoyi, Helen Joseph, Sophie de Bruyn, and Ramima Musa. More than 20,000 women of all races marched to the Union Building in this country at the heightened time of apartheid in 1956 to demand the scrapping of the past laws, asserting themselves through a firm, slogan that says, "Watinta abafazi, watinti mbokodo." You strike a woman, you strike a rock. These brave women stood firm to tell their oppressors and the world at large that they too were their own liberators. Not only were they fighting for the end of racial and class discrimination, but they also fought for the unconditional end of gender discrimination. The 1956 Women's March is part of a major blows that led to the collapse of the apartheid system in our country and led to the advent of our democracy in 1994. It was because of this breakthrough that 1996 we adopted the Constitution whose 30th anniversary we are celebrating this year. This document, which is a symbol of people's struggle, contains the Bills of Rights, which amongst others say that everyone is equal before the law and has the right to equal protection and benefit of the law, and that the state may not unfairly discriminate directly or indirectly against anyone on one or more grounds, including race, gender, sex, pregnancy, marital status, ethnicity, or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, and birth. In this respect, our Constitution anticipated the Maputo Protocol, which has just turned 20 a few months ago, which amongst others says that state parties shall combat all forms of discrimination against women through appropriate legislation, institutional and other measures. In this regard, ladies and gentlemen, they shall include in their national constitution and other legislative instrument, if not already done, the principle of equality between women and men and ensure its effective application. It further demands that states shall enact and effectively implement appropriate legislative or regulatory measures, including those prohibiting and curbing all forms of discrimination, particularly those harmful practices which endanger the health and general well-being of women. In the last 30 years, ladies and gentlemen, we have learned that codification of legislation or regulatory does not always translate into implementation. The achievement of gender equality requires a deliberate set of implementable actions that are conceptualized with a gender perspective. We all know that power concedes nothing without demand. As a writer, Arundhati Roy, the famous Indian author, activist and feminist, put it, I quote, "Power rarely says no to women directly. It delays, redirects, and exhausts them instead," unquote. Without implementable policies and programs, conceptualization with a gender perspective to empower women, women will continue to be delayed, to be redirected, but most worse, to be exhausted of fighting. As it happens in many countries around the world, South African women continue to experience high levels of pernicious discriminations and violence. And despite the plethora of progressive rights-based legislation in our country, we cannot claim that we are closer to delivering on the aspirations embedded in the Convention on the Elimination of All Forms of Discrimination Against Women, the Maputo Protocol, the Constitution, the Sustainable Development Goals to promote gender equality and empower women. Ladies and gentlemen, the phenomenon of the abuse of women spans all continents, although the way it occurs presents different or is presented differently in each continent and in each country. Collaboration and cooperation to effectively address the scourge and the scourge of gender-based violence and femicide is imperative, and the sharing of experiences, exchanges of resources, and best practices, serves to empower women and will assist us to change the status quo. Women in our various countries continue to bear the brunt of this scourge of gender-based violence and femicide. Its effects have been that of a devastation to families, scaring of communities, and undermining the rule of law. It is for this reason that our President, His Excellency President Cyril Ramaphosa, has declared gender-based violence and femicide a national disaster. Accordingly, South Africa developed a response, the National Strategic Plan on Gender-Based Violence and Femicide, a multi-sectoral, rights-based framework that seeks to eliminate gender-based violence through coordinated prevention, protection, accountability, and support services. In addition to this, government has also put in place a number of strategies to strengthen gender-focused jurisprudence in our quest to fight the scourge of gender-based violence and other discriminatory practices, including but not limited to the following: expansion of specialized sexual offenses courts and Tutuzela care centers, which are designed specifically to deal with gender-based violence; strengthening of legal protection through gender-based violence legislative reforms, and online application service of domestic violence protection orders, and the delivery of such protection orders even through social media such as WhatsApp; judicial and prosecutorial training on gender-sensitive and victim empowerment; development of Femicide Watch to collect data and monitor gender-based violence and femicide incidents and trends; engagements with traditional leaders and community forums to ensure we embed the values of the Constitution in every corner of our society, ensuring that custom and culture do not undermine women's dignity and safety. Furthermore, ladies and gentlemen, let me take this opportunity to commend and congratulate Chief Justice Maya for the anti-sexual harassment initiatives in concrete steps that she has taken. Last year, she launched the awareness, and also the policy has driven awareness and advocacy across the country and courts, and ensured that everybody understands that within the judiciary, this is a safe place for women to work. And I want to commend you for that, Chief Justice Maya. Women's access to the legal profession and the judiciary in South Africa has been significantly advanced since the adoption of the Constitution in 1996. However, even today, there remains an underrepresentation of women in some of the areas, in some of our benches. Those that occupy this important position are confronted by a myriad of challenges that impede on attaining true equality in South Africa and the rest of the world. Our sisters from the African continent and the rest of the world can attest to the similar patterns. However, it is important to acknowledge the strides that we have made. Our country has made huge strides in empowering and affirming women jurists in the judiciary. At the advent of our democracy in 1994, our judiciary was comprised of 165 judges, of which 160 were white males, 3 black males, and only 2 white women. South Africa had no black woman judge in 1994. Today, there are about 255 judges in the superior courts, of which 131 are men and 124 women judges. Progress has been made. However, still more to be done. And I must say, last week we had almost about, we recommended, Judicial Service Commission recommended 2 women to SCA, 3 women to Western Cape Division of the High Court, and 3 women to the Eastern Cape Division of the High Court. We look at our country, the 2 most powerful courts, if I may call them that way, are led by women: the Constitutional Court and the Supreme Court of Appeal, led by President Molemele. Out of the 15 superior courts, 6 of these courts are led by women. This is the milestone we've made and will continue to thrive. On the magistracy, ladies and gentlemen, we fared much better in terms of gender transformation, in that of the 1,626 magistrates appointed permanently, 898 of them are women. This means we are sitting at 55% of women representation at this level. We are immensely proud that women in the judiciary continue to lead in our quest to transform our jurisprudence on gender equality, reproductive rights, and the protection of the vulnerable. Their presence in the judiciary is in line with the vision of our constitutional order. This gathering today, ladies and gentlemen, provides for all of us here with an opportunity to strengthen collaboration and share expertise while advancing constitutional justice and gender equality. There's a need to learn from one another, support one another, protect one another. Many of you have personal stories about the obstacles that you've had to overcome and the walls you had to break down for you to get where you are today. These stories, when properly documented and shared amongst women, will serve as the foundation upon which the next generation of women will find strength to stand tall and claim their rightful place in the world. As women judges, your lived experiences provide better insights into the realities behind the cases. The resilience and courage of the delegates attending the conference is not only personal, but it is structural. It reshapes how law is interpreted, how justice is delivered, and how society evolves. This meeting should not only be used to exchange insights, but to sharpen our collective commitment to the law that heals, courts that transforms, and systems that centers around humility. I look forward to the deliberations and thank you very much for inviting me. Together we can create a world in which men and women are equal. Thank you.
Let's give the minister another round of applause. Thank you very much, Minister. We are going to have a presentation by the Honorable Lady Justice Shafika Benswawala, who is the Vice President of the African Court on Human and People's Rights. She's going to do so in French, so kindly make sure that you have your devices handy. And for purposes of a translation, 1 is English, 2 Arabic, French, they are covered, 4 Portuguese. Maybe we, okay, fine. Music, something. Thank you. Ladies and gentlemen, please help me to welcome Vice President to the stage, to the podium.
So I have the pleasure today to represent the African Court today, and I would like to say in my name and also all the judges of the court what follows. Ladies and gentlemen, all protocol, the adoption of the protocol of the African Charter on Human and People's Rights on the Right of Women in Africa, known as the Maputo Protocol on the 11th of July 2003, constitutes a decisive step in the evolution of African human rights law. By breaking with a purely formal conception of equality, this instrument enshrines substantive rights contextualized and rooted in African socio-cultural realities. It is distinguished in particular by the recognition of innovative rights, such as reproductive rights, the fight against gender-based violence, and the eradication of harmful traditional practices. However, the existence of an advanced normative framework does not in itself guarantee the effectiveness of the enshrined rights. As in other regional human rights protection systems, the transformation of norms into truly enforceable rights depends closely on their judicial appropriation. In this regard, the African Court of Human and People's Rights stands out as a central actor in the judicialization of the Maputo Protocol. The empirical analysis of the cases submitted to the court allows to understand this dynamic concretely. Between 2006 and December 2025, the court was seized of 21 cases relating to women's rights or involving women from 6 African states. These cases cover a wide spectrum of violence, violation ranging from civil and political rights to economic, social, and cultural rights, as well as structural issues such as gender-based violence, inheritance discrimination, educational exclusion of pregnant girls, and accusation of witchcraft. However, beyond the diversity of the alleged violations, a quantitative and qualitative examination of the litigations reveals a still incomplete structuring of the case law, as illustrated in this diagram. So 4 cases of incompetences, or 2 cases, against a limited number of judges, against a number that is limited, that more than half of the litigations remain pending to the cases. So this configuration translates a double reality. On one hand, the existence of procedural obstacles persisting, limiting the executive access to the court, the famous Article 36(4) that asks the states to make a declaration of skills. So states that do not make that declaration stop their citizens to come to the court. So this is a very main obstacle, and on the other hand, also a jurisdictional transition that is marked by a progressive increase of litigations in consolidation. So, far from constituting a simple statistic indicator, this kind of litigation shows structural tensions that go across African system of protection of women's rights, tensions between normativity and effectivity, between jurisdictional accessibility and procedural constraints, between acknowledgement of rights and transformation of social practices. In this context, the African Court appears not as a judge of violations, but also as an actor of transformation, normative transformation, contributing to the progressive emergence of African norms of women rights. Now, this dynamic is as much as significant and is inscribed in an environment that is marked obviously by social, cultural resistance and also institutional barriers that are persisting. So now the central question that we need to ask is the following: is in which measure is the African Court of Human Rights and People contribute to the effectivity of the Protocol of Maputo and also the building of an African Constitution of Women, despite structural constraints that are affecting its functioning? So the jurisprudence of African Court of Human Rights and People relative to the Protocol of Maputo, although it is still quantitative limited, reveals a structuring dynamic in the transformation of this instrument in legal binding norms. And since its creation in 2006 and December 2025, the court had 21 questioning either directly or indirectly the women rights, and nevertheless the analysis of these litigations question a structuration that has not yet been set up. As I said it, we only have 3 cases that brought about decisions, 3 cases that were rejected because of incompetency, and currently we still have 11 cases that are pending. Now, this configuration reveals at the same time the procedural limits, the Article 36(4), and also the systems and the potential of a litigation in construction. So on one part, the normative density of the Protocol of Maputo, and on the one another end, the barriers to its legal effectivity. Now, in this context, the court operates a double legal movement. It talk about the direct rights in the protocol by progressively precising their normative scale through an interpretation that is systemic of African instruments as well as international. Now, this jurisprudence construction is illustrated particularly through two big cases. Firstly, we've got the case APDF and AHDR with Mali and the Association for Progress and Defense of Malian Rights and the Institution of Human Rights and Development in Africa, which constitutes the foundational decision regarding the direct application of the Maputo Protocol, and the case of Glory Syriac Osu against the Republic of Benin 2024, which extends its application to the sphere of family law. I'm going to just give you an overview when it comes to this. For the first one, the APDF and IHRDR in Mali, the judgment of May 2018 constitutes the first substantial and explicit application of the Maputo Protocol by the African Court, thus marking a decisive step in the jurisdictionalization of women's rights in Africa. The fact the applicants challenged several provisions of Malian Code of Persons and Family, precising the Code of the Family 2011, on the grounds that they were incompatible with international standards of the protection of women's rights. The contested provisions included the minimum age of marriage set at 16 years for girls, recognition of religious marriage without sufficient guarantees of consentment, inheritance rules that are discriminating against women. Now, these standards reflected a deep tension between domestic law, influenced by socio-cultural and religious considerations, and Mali's international commitment. Now, the central question submitted to the court was therefore that of compatibility of this provision with the Protocol of Maputo. In particular, Article 2 relating to the elimination of all forms of discrimination against women, Article 6 relating to marriage, as well as implicitly Article 5 relating to harmful practices. The court, the reasoning towards an interpretation, theological and systemic. The court adopts a combined and theological approach by mobilizing firstly the Maputo Protocol, then the African Charter of Human and People's Rights, and the African Charter on the Right and Welfare of the Child. Now, in doing so, the court is building that the minimum age of marriage must be set to 18 years without distinction. Free and informed consentment is fundamental requirement. Customary and religious practices cannot justify violations, and inheritance discrimination violates the principle of equality. The court thus adopts the theological interpretation aimed at the transforming gender relations. So, obviously, this went towards an African control of conformity. Now, these convention present a major implication. Firstly, the consecration of the direct justiciability of the protocol, affirmation of the primacy of international law, which is also very important, and also the recognition of positive obligations of states. This is also very important. So it inaugurates a genuine African control of conventionality in gender matters in a transformative logic of domestic law. So this is for the first case. Now, for the Glory Syriac case against the Republic of Benin, so this is a 2004 judgment. This affair brand an important extension of law in the field of family law. Now, the facts. The case concerns a provision that exclusively grants the father the right to pass on the family name to the child, creating a contrary discrimination, firstly to Article 2 of the Maputo Protocol, to Article 3 of the African Charter, and also to the international standards of equality. It reveals the persistence of patriarchal structures in the family law. Therefore, the Constitutional Court of Berlin validated the law, illustrating a tension between internal review of constitutionality and internal review of conformity with international convention. Now, the court affirmed in this law the skills or its international control competencies, the autonomy of its office, the primacy of international commitment. So the effect of this litigation was that Benin adopted in 2021 establishing equality in the choice of family name, and the court then notes that after this request, that the request has become without any object. So nevertheless, this dynamic is now inscribed in a context of evolution of a normative framework marked by the adoption of new instruments when it comes to violence against women, which is now interrogating the modality of articulation and the implementation of the protocol. The implementation of the Maputo Protocol in the Convention of African Union of 2025 remains a concrete transformation of the women's right. If Maputo Protocol constitutes of the right of African women, Article 2, it eliminates discrimination. After 3, it talks about dignity. Article 4, the physical integrity and security. Article 5 of harmful practices. Article 14 of reproductive right. And they talk about a global, the new Convention of African Union introduced a much more precise and operational approach. It defines broadly the physical violence and digital, and recognizes femicide. Among others, I'm not going to mention everything because of time. I'm just going to try to conclude, but this document is going to remain with the organizers. Those who would like to have more precision, they can always come back to my document. What interests me more, it is to go to my conclusion, and through this conclusion, I would like to make a recommendation, because that is what is important. In 2023, Africa got itself a more progressive text of the world on women's rights, the Protocol of Maputo. Now, in our days today, 34 states have ratified the protocol, creating the African Court of Human Rights and People, 34, and 44 have ratified the Maputo Protocol. Although the court is the armed arm of the Maputo Protocol, I emphasize. Now, it says no marriage before the age of 18. So the court can condemn the state that does not apply it. Maputo says right to medical abortion, and the state 34 states out of 55 acknowledges that. The challenge is to access it. Now, the barriers is of the solution to Article 36.4. These are, we need to remove these blockages. By who? By us. But now the problem, no NGO or women that go straight to the court, the state must have signed a special declaration of competency. Up to today, 7 states out of 34 have signed. I'm not going to sign those who restricted themselves. A woman from Burkinabe, Gambian, Malawian, Nigerian, Malian violated can go to the court. But the scandal, silence scandal, if the court exists and Maputo exists, so 26 states forbid or are forbidden to listen to their citizens. 26 states. South Africa, the country of Mandela and the most progressive constitution of the world, everyone says it. I'm not the only one to say it, has ratified Maputo in 2004. and the court in 2002, but has not made any declaration. Here is the paradox of our meeting here in Johannesburg. Now, we are calling upon all the states that have ratified Maputo to make the declaration before the date of 24 years in Maputo. Mandela opened the way to liberty in 1994. Women of Soweto, they bear the fight of 1976. Now, the Maputo has opened the door. I would like to say thank you for your attention.
Merci beaucoup, Madame. Gentlemen, it is my great honor and privilege to introduce to you our keynote speaker for this session, a trailblazer, a visionary, and a pillar of justice in South Africa and beyond. I'm talking about our Chief Justice Mandisa Muriel Lindelwa-Maya. Her journey is nothing short of extraordinary. She has risen through the ranks of South African Judiciary to become the first woman to hold the highest office, I forgot about this now, in the country. And she was appointed as a CCJA in 2024. Her appointment marks a historic milestone, not only for South Africa, but for the advancement of women in the legal profession. Her academic credentials are impressive and reflect a lifelong commitment to excellence. She holds a BProc degree from the University of Transkei, an LLB from the University of Natal, and an LLM from Duke University in the US, where she studied on a prestigious Fulbright scholarship. She has been honored with 4 Doctor of Laws honoris causa degrees from leading South African universities in recognition of her outstanding contributions to the jurisprudence and women's empowerment. Chief Justice Maya's legal career is as diverse as it is distinguished. From humble beginnings as an attorney's clerk, a court interpreter, a prosecutor, to a pivotal role as a case investigator during South Africa's first democratic elections in 1994. I must say our minister could not vote in 1994. We were working at the time. She has demonstrated unwavering dedication to justice and democracy. She practiced as an advocate, taught law, served in various judicial capacities across multiple courts, including the High Court, Labour Court, Supreme Court of Appeal, and now at the Constitutional Court. And have served as a president, deputy president, and president of the SCA, deputy chief justice, before she was appointed as a chief justice. She also serves as the chairperson of the Judicial Service Commission, as well as the South African Judicial Education Institute. She also serves in various other organizations, to name but a few: South African Institute for Advanced Constitutional, Public Human Rights, and International Law. And she also has been involved in the a number of boards: National Bar Examination Board, the Law Faculty Board of University of Free State, the Editorial Board of the University of Transkei Law Journal, and the Advisory Board of the Yearbook of the South African Law. And recently, I believe, in 2020, she joined the Bold Judicial Institute Leadership Council at Duke Law School, furthering her international impact. She was appointed in 2021 as a Chancellor of the University of Mpumalanga, a role she continues to fulfill with distinction. I'm talking about uMagadebe, uHlubi, uMakhulukhulu, intombi yaseQhukwala ngaphesheya kwenciba. Please, ladies and gentlemen, join me in welcoming a jurist of global structure and deep local impact, Chief Justice Maya.
Thank you for that kind introduction, Madam Program Director. You know, when you start invoking a person's clan names, you touch the deepest part of their being. Thank you, Majola Mangwani. Speaker of the National Assembly of the Republic of South Africa, Ms. Tokotitiza, Minister of Justice and Constitutional Development, the one who could not vote yet in 1994, Ms. Mamloko Kubai, Minister in the Presidency for Women, Youth and Persons with Disabilities, Ms. Sindisiwe Chikunga, President of the Supreme Court of Appeal of the Republic of South Africa, Justice Mahube Molemela, President of the Constitutional Council of the Republic of Mozambique, Justice Lucia Ribeiro, Chief Justice of the Supreme Court of the Federal Republic of Nigeria, Justice Kudirak Kekere Egon, President of the Supreme Court of the Gambia, Justice Salah Wada, Chief Justice of England and Wales, Dame Suka, Baroness of Walton on the Hill, joining us online, President of the Constitutional Court of the Republic of Burundi, Justice Valentin Bagorikunda, Vice President of the Constitutional Court of the Republic of Angola, Justice Victoria Izata, Vice President of the Constitutional Court of the Republic of Chad, Justice Aminata Ache, Deputy Chief Justice and Vice President of the Supreme Constitutional Court of the Arab Republic of Egypt, Justice Fatima I always struggle to pronounce your name, El Razaz, Vice President of the Constitutional Council of the Republic of Senegal, Justice Aminata Ndiaye, Deputy Chief Justice of the Republic of Zimbabwe, Elizabeth Gwaunza, Vice President of the African Court on Human and People's Rights, Justice Shafika Ben Saula, honorable judges and justices representing respective jurisdictions in the continent, esteemed members of the South African Judiciary, Ms. Musa Laraba, the rose among the thorns, Secretary General of the CCJA, our special guests and women leaders from civil society, members of the legal fraternity and academia, our sponsors and partners, UNDP, UNESCO, Tourism SA, JUTA, PPS Insurance, and many others I can't mention in the interest of time. Esteemed guests, members of the public following these proceedings online, members of the media, good morning. It is indeed a distinct honor and pleasure to welcome you all to this gathering, which marks the second high-level meeting of women judicial leaders of Africa, hosted by the Conference of Constitutional Jurisdictions of Africa, the CCJA, in collaboration with the South African Judiciary as a member of that august body. We are very proud and truly delighted to host this gathering in our beautiful country and share with you our rich cultural heritage and stunning fauna and flora. South Africa prides herself on her warm and exceptionally hospitable people, and indeed, many of you have expressed their appreciation for the warm reception you receive from the moment you touch down at our Oliver Tambo International Airport. We do hope that you will feel at home during your stay in the City of Gold while building meaningful connections. I wish to extend a hearty welcome to the leader of South Africa's legislative branch, the Speaker of the National Assembly, Honorable Ms. Didiza, and the representatives of our executive branch, Minister of Justice and Constitutional Development, Minister Kubai, and Minister in the Presidency for Women, Youth and Persons with Disabilities, Honorable Ms. Chikunga. We thank you for being part of this important event. Your attendance reaffirms our government's commitment to our collective efforts to advance the vision of our Constitution, and your leadership has been instrumental in driving various initiatives that seek to protect the rights of vulnerable members of our society and support the empowerment of women. As the judiciary, we are eternally grateful to you for your consistent support. I also extend a warm welcome to our distinguished guests, the CCJA member heads and representatives of Supreme and Constitutional Courts of the various jurisdictions across the African continent in attendance, and all our other esteemed international colleagues, including the Vice President of the African Court on Human and People's Rights, Justice Bensaoula, and the Lady Chief Justice of England and Wales. We are profoundly grateful for your attendance and look forward to strengthening our ties further and fostering a spirit of cooperation that will yield positive outcomes for our judiciaries and the communities we serve. Your presence enriches this gathering and highlights the importance of international cooperation in advancing justice, promoting the rule of law, and protecting human rights. I would also like to welcome and express our deep appreciation to our other key collaborators and sponsors, representatives from the United Nations Development Programme, UNDP, the United Nations Educational, Scientific and Cultural Organization, UNESCO, Juta and Company, the Professional Provident Society, which we call PPS, South Africa Tourism, and many others. And to all the other luminaries present here today and our speakers, of course, it is an honor to have all of you in our midst, and we appreciate that you have taken your valuable time to join us despite your busy schedules. This meeting comes at a profoundly symbolic moment. Precisely 20 years since entry into force of the protocol to the African Charter on Human and People's Rights on the rights of women in Africa, also known as the Maputo Protocol, which the previous speakers have alluded to. In November 2005, the Maputo Protocol, which has been ratified by 46 nations, stands as Africa's most progressive legal instrument, offering comprehensive protection of women's rights as it mandates member states to eradicate gender-based violence and harmful practices, secure women's economic and social empowerment, and guarantee parity across our continent's political and judicial institutions. Simultaneously, as has been mentioned, we mark 30 years of the South African Constitution passed in 1996, which serves as the cornerstone of this nation's democracy and constitutes an unwavering beacon of equality, dignity, and freedom. Its transformative jurisprudence has inspired courts continent and worldwide to bridge law and lived reality. Together, these milestones frame our urgent mandate, which is to consolidate Maputo's vision through constitutional justice, ensuring that women's leadership on the judicial bench drives equality for the next generation. Distinguished guests, please allow me to take you a few steps back to the beginnings of this crucial platform. The first high-level meeting of African women judges held in the first week of May 2023 in Libreville, Gabon, was nothing short of a continental milestone, a gathering of judicial leaders from 35 African nations in a first-of-its-kind meeting hosted by the CCJA and Gabon's Constitutional Court, with pivotal support from UNDP, the United Nations Office on Drugs and Crime, and UN Women. This groundbreaking assembly brought together African women heads of jurisdictions, vice presidents, and members from diverse nations such as Gabon, South Africa, Algeria, Kenya, Malawi, Eswatini, Mozambique, Benin, Angola, the Gambia, Egypt, Morocco, Comoros, Ethiopia, Djibouti, CAR, Senegal, Zimbabwe, and many others. This first high-level meeting was a landmark gathering of senior women judicial leaders, which ignited Pan-African judicial dialogue on gender justice, constitutional rights, and the rule of law. Their resolutions were forced to advance women's rights under the Maputo Protocol, to review progress, identify gaps, and pledge collaborative jurisprudence. That meeting was not just a talk shop, as many conferences end. It was a launch pad with a deep purpose. Its lessons are documented in the agenda, this meeting's agenda, particular session 1, which seeks to ensure continuity as we reflect from Libreville to Johannesburg. Under the theme, The Presence of African Women in the Judiciary, Assessment and Perspectives, Libreville created a resolute framework for reflection on the universal barriers to women's judicial entry, cultural, legal, institutional, and social obstacles which impact their constitutional rights enforcement, and of course the gains in the appointment of women to the bench across civil and common law traditions. The sessions dissected 3 sub-themes. The first, experiences, best practices, and barriers to promoting women judges. The second, justice sector support via regional learning. And the third, actions for transparent access to judicial roles. At this seminal meeting, the South African Judiciary was represented by none other than our program director, Justice Mhlandla of the Constitutional Court of South Africa, who presented the gender statistics of our magistracy and superior courts and the role of the South African Judicial Education Institute, the CCJA as we call it. She was accompanied by the president of our Supreme Court of Appeal, Justice Mulemela, who shared her own journey in the judiciary through the CCJA's brilliant Aspirant Women Judges program, which was created by far-sighted and intrepid women, led by the first woman Minister of Justice of Democratic South Africa, Ms. Bridget Mabandla, and the South African chapter of the International Association of Women Judges 30 years ago. President Mulemela's account of her appointment in the High Court and the CCJA's revival of the Bridget Mabandla Aspirant Women Judges program, as it is now called, which unfortunately lost crucial financial and logistical support from government and died when Minister Mabandla's tenure in the Justice Ministry ended, inspired continent-wide replication calls from heads of court and ministries. The engagements in this first meeting laid bare the reality of gender inequity, which persists to this day in the judicial space across the continent and indeed across the world. Despite the equality mandate in Article 8E of the Maputo Protocol, calling for equal representation of women in the judiciary, and the gains achieved, such as 50% women judges in some countries, and the 511 female bench of the African Court on Human and People's Rights, gender parity continues to lag significantly in African judicial systems. The barriers which persist include deeply rooted cultural and religious stereotypes, flaws in selection and recruitment processes despite commitments, common law impartiality gaps, absent or inadequate gender-sensitive institutional policies, mentorship voids, and judges' realities of discrimination, bullying and harassment, threats, work-life balance strains, which you are all familiar with, faltering political will and entrenched patriarchal structures continue to confine women and their influence to lower-level positions, registries or administrative roles, rather than high-level decision-making power. Although these obstacles play out differently for different women globally, most are quite common for all of us. The meeting culminated in the Libreville Declaration, a strategic blueprint noting women's leadership capacity, their unique and positive impact in the judiciary, and justice access disparities which harm women. It pledged actions including identifying entry and promotion obstacles in the justice sector, identifying replicable good practices and measures to advance women's participation and their strategic positioning in judicial institutions, stock taking on the state of gender equality in judicial systems, promoting awareness of the advantages of gender parity, creating structured and continuous engagements, physical or online, for CJCA members to ensure sustained progress in the objectives of the gathering. As I've said, this meeting marked the beginning of a movement whose spirit of bold assessment and solidarity anchors this conference, which will review progress, gaps and challenges, operationalizing the Libreville Declaration through Maputo theme sessions, research briefs, and craft the Johannesburg Declaration 5-year action plan. This meeting carries an even greater imperative as we consolidate gains from Libreville and propel gender justice forward across our continent. At its core, the meeting fosters high-level judicial dialogue on the multifaceted barriers to women's full participation in the judiciary, the unique challenges women judicial officers faced in upholding constitutional rights, and the transformative role courts play in advancing the rule of law through a gender lens. We will interrogate persistent obstacles ranging from cultural stereotypes and biased appointment processes to institutional gaps in mentorship, gender-sensitive policies, and political support. Simultaneously, we'll focus on forward-looking strategies and concrete measures to drive progress. This includes promoting inclusive environmental decision-making for the economic and political advancement of women, and exploring how artificial intelligence can be leveraged to safeguard human rights and not cause harm, as Madam Speaker Didiza indicated earlier. Well, I suppose every advance comes with disadvantages, Madam Speaker. We will also take a moment to acknowledge and celebrate the strides made in representation and leadership, such as South Africa's progress towards bench parity and specialized training programs. Broadly, our discussions will traverse critical domains of jurisprudence under the Maputo Protocol, including the adjudication of violence against women, encompassing domestic violence and femicide, which unfortunately South Africa takes the lead in the entire world for having the highest statistics, and harmful practices as enshrined in Article 4, economic empowerment through property, inheritance, and financial inclusion rights under Articles 13, 19, and 21, environmental justice and women's participation under Article 18, sexual and reproductive health rights under Article 14, navigating cultural and policy tensions, and the digital frontiers implications for women's rights, from AI-driven access to justice to combating online violence and safeguarding privacy. These themes demand comparative insights from civil and common law traditions, spotlighting landmark judgments that dismantle discriminatory customary laws, hold states accountable, and integrate gender into emerging frontiers, such as climate change and technology. Judicial wellness and resilience, which are sadly neglected in an extremely demanding environment, mentally and physically, emerge as foundational imperatives, addressing the psychological burdens, gender-specific pressures, and sustainability challenges that threaten our longevity on the bench and beyond. Yesterday was richly rewarding as we explored best practices for self-care, peer support, and institutional reforms to foster resilient leadership. Guided by our research team's authoritative outputs, concise judiciary country profiles detailing structures, hierarchies, women's representation, and reforms, alongside thematic briefing papers synthesized from judgments, legislation, and reports, this gathering transcends reflection to produce enduring tools in the form of the Johannesburg Declaration, the 5-year action plan to which I alluded earlier, consolidated jurisprudential resolutions, a strengthened network of women judges, and a comprehensive proceedings compendium. These valuable tools will equip courts across our continent to deepen the implementation of the Maputo Protocol and ensure that women's rights are not aspirational, but adjudicated realities for this and the next generation. It is worth mentioning that this meeting of African women judicial officers aligns with the commitments of the United Nations and the African Union regarding equality and women's rights, and amplifies judicial action to translate global and continental commitments into enforceable jurisprudence. The United Nations Sustainable Development Goal number 5, gender equality, calls for ending violence, ensuring equal legal protections, and boosting women's leadership participation by 2030, just around the corner. This goal is mirrored here through our thematic focus on Maputo Protocol Articles 4 to 5, which focus on violence eradication, harmful practices elimination, and wellness and resilience sessions addressing judicial gender burdens. The United Nations Women and the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, principles on state accountability for domestic violence, femicide, and economic exclusion resonate in Session 2's adjudication strategies and research team's comparative case studies, while the UN Office on Drugs and Crime and UNICEF data, which document staggering figures of a 38% domestic violence prevalence and 79 million child rape survivors, and underscores the urgency for victim rehabilitation and prevention. At the African Union level, the Maputo Protocol, our meeting's lodestar, imposes binding obligations for parity, violence prohibition, and cultural reform. The protocol is reinforced by the 2024 African Union Convention on Ending Violence Against Women and Girls, a Salima initiative, which is a continent-wide campaign spearheaded by the African Union to eliminate female genital mutilation, as Justice Bensau mentioned earlier, and the Agenda 2063's Gender Justice Pillars, which calls for an Africa whose development relies on the potential of African people, especially its women and youth. And Libreville's 2023 declaration kicked off this movement. Our discussions and strategic planning on economic empowerment, it is Articles 13, 19, and 21, the reproductive rights, and the digital world will ensure that courts led by women like us deliver through equality that changes lives from the courtroom to everyday life in our communities. This meeting, which as I've said, aims to build on foundational dialogues and networks established in Libreville, is a step forward in strengthening the role of women judicial officers in advancing constitutional justice and gender equality across Africa. Before we can assess the progress made since the first high-level meeting in Libreville, and there has been progress, I seek your indulgence to take a moment and reflect on the role of women in the judiciary. Judicial officers are entrusted with the pursuit of truth and the protection of human rights, and ensuring that justice is not merely an ideal, but a lived reality for all. In fulfilling this mandate, it is imperative that the persons who serve in this institution mirror the diverse societies they serve. Gender representation is not a peripheral concern, but a critical factor in the legitimacy, effectiveness, and fairness of our legal institutions. When all the genders are equitably represented, I've been talking for too long, excuse me. When all the genders are equitably represented, the justice system gains broader perspectives, a richer insight, and deeper empathy, thereby enhancing its capacity to deliver justice impartially and inclusively. Therefore, ensuring gender balance within the judiciary is a vital step towards realizing the full promise of justice in society. It must be said that generally, the performance of African countries in ensuring adequate women representation in the judiciary is encouraging compared to the other branches of government. The Ibrahim Index of African Governance, the AIIG, subcategory on women's equality measures the extent to which women are represented in the highest branch of the judiciary. And so a country scores a full mark of 100 if at least 33% of the senior positions in the judiciary are women. According to the 2022 AIIG report, Africa scored 68.5 out of 100 in respect of appointments to the highest judiciary branch in Africa. This figure was boosted by the high female representation in the judiciary in Southern and East African countries, scoring impressive 77.5 and 73.2, respectively. Encouragingly, even North Africa, which unfortunately is noted for weak women's rights and representation, scored 62.3, but only 21 of Africa's 55 countries have attained the target of at least 33% women in the highest branch of the judiciary over the last decade. Most dishearteningly, countries such as Guinea-Bissau, Egypt, Somalia, Sudan, and South Sudan have performed particularly poorly in ensuring women's representation in the highest branch of the judiciary, and we fervently hope for change. Notably, the African Court on Human and People's Rights has raised the total representation of women on its bench to 46% by recently electing 2 more women. Similarly, Minister Kupai mentioned some of this. Similarly and very proudly, so has the South African Apex Court, the Constitutional Court, which had 2 women, Justices Dambuza and Savage, who are among us here, join its ranks just last week, thus bringing the number of women judges in the South African Constitutional Court to an historic majority of 6 in a complement of 11 judges. For the first time since that court's birth 30 years ago, the importance of gender parity lies in its ability to uphold the principles of fairness and equality within democratic institutions. A judiciary that mirrors the diversity of society strengthens public trust and reinforces the idea that justice is impartial and inclusive. Representation is not symbolic. It is a substantive requirement for legitimacy. As the United Nations Special Rapporteur on the independence of judges and lawyers has emphasized, gender equality in the judiciary is directly tied to the rule of law and access to justice and aligns with global commitment under the Sustainable Development Goals. As the program director said, women judges contribute perspectives informed by their lived experiences, which are often different from those of men. Their inclusion enhances judicial reasoning, producing decisions that are more empathetic and nuanced. Studies indicate that courts with diverse panels engage in deeper deliberation, question entrenched assumptions, and deliver outcomes that are fairer and more inclusive. In the South African context, particularly after apartheid, women judges have played a pivotal role in shaping jurisprudence in areas such as family law, gender-based violence, and workplace discrimination, fields where attentiveness to social realities is especially important. Moreover, increased representation of women in the judiciary helps to counteract gender-based discrimination within the legal system itself. By ensuring gender parity, courts are better positioned to recognize and address certain forms of bias, thereby strengthening protections against unfair discrimination. Legislative reforms and constitutional mandates, such as South Africa's requirement that judicial appointments consider both racial and gender composition highlight the importance of representation in dismantling systemic inequalities. In essence, gender parity is not only about fairness in opportunity, but also about transforming the justice system into one that is more empathetic, inclusive, and capable of delivering equitable outcomes. A judiciary enriched by diverse voices is better equipped to uphold human rights, protect dignity, and ensure that justice is not an abstract ideal, but a lived reality for all. Turning to the progress made since the inaugural high-level meeting of women in Libreville, African jurisprudence on gender equality has witnessed notable advancements, building on the Libreville Declaration's call for parity, burial, removal, and judicial reforms. For instance, in 2024, the ECOWAS Community Court of Justice ruled against the Republic of Sierra Leone in a case that challenged the country's loitering laws, which were argued to unjustly target the poor and vulnerable and violate fundamental rights. The court found that Sierra Leone's loitering laws infringe on the rights to equality and non-discrimination and freedom of movement, declaring that the enforcement of these laws disproportionately affects marginalized persons who invariably will be women. Under the legislation, individuals could be arrested based solely on a subjective assessment by law enforcement officers that a person has failed to give a satisfactory account of themselves. This vague criterion led to arbitrary detentions, primarily of low-income individuals who are often unable to avoid these arrests due to their socio-economic circumstances. In its submissions in this case, Advocate also brought to light egregious abuses suffered by women arrested under these laws. The case documented instances where women who could not afford bribes were subjected to sexual exploitation by police officers as a condition for release. In some cases, women were forced into non-consensual sexual acts, often without any form of protection, further exacerbating their vulnerability and trauma. The ECOWAS Court's judgment affirms that Sierra Leone's loitering laws contravene the principles of equality before the law and the rights to non-discrimination and freedom of movement. In its ruling, the court ordered the government of Sierra Leone to take appropriate measure to amend or repeal its loitering laws, emphasizing the need for legislation that upholds the rights of all citizens and protects against arbitrary arrest and abuse. Another example is how the South African Constitutional Court found that Section 7 of the country's Divorce Act was unconstitutional on the basis that it failed to include marriages entered into on or after the commencement of the Matrimonial Property Act of 1984. Section 7.3 of that statute stipulates that in cases where spouses married out of community of property get divorced, the court may make an equitable order that assets of one spouse be redistributed to the other. However, this remedy was only available to civil marriages concluded before 1 November 1984. The rationale behind this exclusion was that marriages concluded after this date would automatically be subject to accrual unless expressly excluded by an antenuptial contract. The Constitutional Court found that while the differentiation based on date of marriage was rational, it constituted indirect gender discrimination against women and is therefore unconstitutional. The court recognized that the indirect impact of excluding new antenuptial contract marriages in terms of Section 7.3 disproportionately affects women. Referring to research, the court highlighted that South African women are more prone to multidimensional poverty compared to men, with the burden of poverty falling even more heavily on Black women. This is the kind of jurisprudence that women make possible. Outside the courtroom, there have also been initiatives adopted that promote equality for the next generation. This includes progress in judicial leadership that features judicial education and training expansions, such as the Bridget Mabandla Aspirant Women Judges Program I mentioned earlier. Please allow me to briefly outline the background of this important training initiative, which has played a critical role in the growth of gender parity in the South African judiciary. The original Aspirant Women Judges Training Program was conceived by the South African chapter of the International Association of Women Judges under the leadership of its first president and South Africa's first Black woman judge, retired Judge Lucy Mailula, who was appointed as a judge at the dawn of democracy in 1994. As Minister Kupai mentioned earlier, at that stage, there were only 2 women judges in South Africa. Justice Van der Heefe, who passed away recently, who had been appointed in 1969 and remained the only woman judge in the country until 1993, when Judge Traverso was invited to act as a judge in the then Cape High Court and subsequently appointed permanently in early 1994, followed shortly by Judge Mailula, and a very slow trickle of women judges thereafter. So there were practically no women in the South African judiciary at the dawn of democracy, and means had to be found to cure this anomaly. This program was thus designed in response to the stark gender disparities in the judiciary at the time, to empower women to ascend to judicial positions and to equip them with the necessary skills and expertise to succeed on the bench after their appointment. And we have reaped and are still reaping the rewards of that initiative. Similarly, our counterparts in East Africa, Kenya's Collective Empowerment Network, launched in December 2024 by the International Association of Women Judges and the Kenya chapter, partnered to implement a Women in Leadership in Law, we call WILIL initiative, that establishes a collective empowerment network for women judges in the Kenyan judiciary. This initiative seeks to transform the judiciary by creating an enabling environment for women judges to rise and thrive by enhancing their professional satisfaction, voice agency, and leadership opportunities. The program aims to improve the rate of entry into and retention in the judiciary, as well as promote sustainable leadership pathways for women judges through mentorship, communities of practice, dialogues with justice sector actors, and leadership development trainings and workshops. These are but a few examples of initiatives and strides that some countries have made since the inaugural high-level meeting of women judicial leaders of Africa in Gabon. However, despite significant legal and constitutional advances across Africa, from the Maputo Protocol's binding protections to progressive national constitutions in countries such as South Africa, Kenya, and Rwanda, women and girls continue to endure pervasive discrimination, violence, and socio-economic marginalization that undermine these gains. The gap between these enshrined rights and the lived reality for millions remains stark. Domestic violence affects 33% of women in sub-Saharan Africa, whilst femicide claims 15 lives daily in South Africa alone. Female genital mutilation persists in at least 28 countries, with a 98% prevalence in Somalia, and conflict zones such as Eastern Democratic Republic of Congo report child rapes half-hourly, exacerbated by underreporting due to stigma, weak enforcement, cultural stereotypes, and resource shortages. Climate change projections threaten to triple intimate partner violence victims to 140 million by 2060, while economic barriers trap women in poverty. These figures are just staggering. Closer to the terrain of the judiciary, the continent faces persistent challenges where certain national laws remain out of harmony with international and regional human rights instruments, particularly on capital punishment and restrictions on abortion. Several African states retain the death penalty, in their penal codes for offenses such as murder, terrorism, aggravated robbery, and treason, with executions still carried out or sentences actively imposed as recently as last year. These laws stand in tension with global norms, such as Article 3 of the Universal Declaration of Human Rights, which safeguards the right of life and prohibits cruel, inhumane, or degrading treatment. While the Maputo Protocol does not explicitly mandate full abolition of the death penalty, it marks a progressive step by restricting its application. Article 42J of this instrument expressly prohibits carrying out death sentences on pregnant or breastfeeding women, implicitly recognizing the disproportionate harm to women and their offspring. This provision aligns with Article 5 of the African Charter on the Rights and Welfare of the Child, which bans capital punishment for crimes committed by children, and the African Commission's repeated resolutions, for example, in 2017 and 2019, urging moratoriums and ultimate abolition across the continent. Equally concerning are national laws in countries that criminalize abortion in almost all circumstances, often under penal codes treating termination as homicide, punishable by life imprisonment or even death. Even in cases of rape, incest, or fatal anomalies, these restrictions clash sharply with Article 14.2c of the Maputo Protocol, which boldly affirms women's rights to terminate pregnancy in cases of sexual assault, rape, incest, or threats to maternal and fetal health, and to access post-abortion care without discrimination. The African Commission has reinforced this through General Comment number 2 of 2014, interpreting the African Charter to protect safe abortion access, while United Nations instruments such as CEDAW, Committee's General Recommendation 24, and SDG Target 5 underscore universal reproductive rights. By maintaining blanket bans, these states not only endanger women's lives, driving clandestine procedures amid high maternal mortality, but undermine the Maputo Protocol's transformative vision and expose the gap between ratification and domestication that demands urgent legislative reform to align national justice within continental equality commitments. Hence the call earlier by Justice Bensaula that those countries, even those countries who have ratified the Maputo Protocol, still needs to do more. They need to declare it. These continental challenges demand more than legislation. They require adjudication that transforms paper rights into lived protections. The judiciary, especially constitutional and Supreme Courts, stand as the foremost guardian wielding interpretive power to close this yawning gap. Women judges bring irreplaceable value. Their critical perspectives, lived experiences, and nuanced grasp of gender discrimination infuse rulings with empathy and precision. Their leadership is pivotal to interpreting laws through a gender-sensitive lens, harmonizing Maputo articles with domestic statutes for holistic violence eradication. They are pivotal to developing robust African jurisprudence on equality via comparative CCJA dialogues that build on Libreville's legacy. They are pivotal to ensuring effective Maputo Protocol implementation, from protection orders to perpetrator punishment and victim reparations, and they are pivotal to enhancing public confidence in the judiciary's commitment to justice for all, countering distrust amid enforcement shortfalls. This meeting directly confronts these hurdles through peer learning among women judicial leaders, strategic CCJA collaborations, and capacity building via research briefs and wellness initiatives, bridging the implementation gap with a Johannesburg Declaration and Action Plan to accelerate tangible progress for Africa's women and children. As we embark on these vital deliberations, let us embrace our collective power to transform these challenges into opportunities for groundbreaking jurisprudence and leadership. This meeting, this gathering, bringing us together at the historic crossroads mentioned by other speakers earlier. Maputo Protocol's 20th anniversary, South Africa's 30th birthday of its constitution, and the 60th anniversary of the 1956 Women's March equips us with peer learning among women judicial trailblazers, strategic CCJA collaborations, and capacity building through our research teams, authoritative briefs, and wellness initiatives. These cannot be overstated. Together, we will forge the Johannesburg Declaration and 5-year action plan, bridging the implementation gap to deliver tangible progress for Africa's women and girls. Distinguished delegates, I wish you successful, inspiring deliberations filled with candor, solidarity, and visionary resolve. Let us make this meeting in Johannesburg a key point in our march towards gender equality. Thank you.
Thank you. Thank you, Chief Justice. I think the Chief Justice has given us a direction. She has set the tone for our meeting for the next 2 days. I'm not going to say more, lest I end up diluting what she has said. We're now going to take group photos, whereafter we'll have a tea break. Kindly request the delegates to remain seated. I know it is a bit longer, but once we leave, we may not be able to finalize the process of group photos. We will start with the Chief Justices, the Presidents, and the Vice President and the Vice Chief Justices. We will kindly request them to join the panel, and then we'll take the photo here. Thereafter, I'll then make another announcement, and then the heads of delegation will join once the Chief Justice's photo has been taken. Thank you. Papi. Yes. The first group is only the Chief Justices, the Deputy Chief Justice, the Presidents of the Supreme Courts, International Supreme Courts, our President, and not just Justice Mela. She's also the President of the Supreme Court of Appeal.
Yes, that's perfect, Justice.
How much time do we need?
This group, they must come to the stage where we're about 45 minutes.
I know, yes.
Justice,
I suspect we'll only do Mr. Lalala, break for lunch, regroup for the 2 sessions. Fortunately, 1 session, we only have he highlighted initiatives undertaken by the CCJA in support and promote women judges in Africa. Thank you, Mr. Laraba.
Good morning, everyone. Bon dia. Bonjour. Assalamu alaikum. Assalamu al-jamia. Before beginning, as you know that my first language is Arabic, but I will try to speak in English. So be patient and indulgent with my English. So, Honorable Mrs. Chief Justice of South Africa, ladies and gentlemen, President of the Court, honorable colleagues, distinguished guests, it's a great honor for me to address this second high-level meeting of women leaders in the judiciary in Africa here in Johannesburg. I would like to express my deep gratitude to the organizer for this initiative, as well as to Chief Justice Mandisa Maya for her inspiring leadership. Established following a decision by the African Union, the Conference of Constitutional Jurisdictions of Africa held its constitutive meeting in Algiers in 2011, with the participation of 25 African Supreme Court and Constitutional Court and Council. 15 years later, the CGCA brings together 50 constitutional and Supreme Courts from all regions of the continent, reflecting its linguistic and legal diversity, as well as for 4 non-African observer members. The CGCA is now a continental framework from cooperation, the largest in Africa, aimed at strengthening constitutional justice, promoting the rule of law, democracy, and the protection of human rights, as well as the principle of equality and equity. In this dynamic, the promotion of women judges has become a major strategic axis of its action. Our gathering today is a continuation of a founding moment, the first meeting held in Libreville in 2023. This historic meeting marked a decisive step in the recognition of the essential role of women in the consolidation of the rule of law on our continent. It has laid the foundations for a network of solidarity committed to promoting a more inclusive, equitable, and socially sensitive justice. The genesis of the first meeting of African women judges dates back to a simple but striking observation participation in the conferences organized by the CGCA was exclusively male. Faced with this reality, the idea emerged that it was necessary to create a space dedicated exclusively to women in order to promote the presence and expression of women judges. This led to the initiative to organize a special meeting for women judges. This idea gradually turned into a real project, which took shape with the holding of the first meeting in Libreville, thanks in particular to the decisive support of the Constitutional Court of Gabon and the United Nations for Development Program. Today, this dynamic continues and strengthens. With the precious support of Mrs. Mandisa Maya, we are witnessing the organization of the second meeting, testifying the sustainability and importance of this initiative. This initiative, launched on the proposal of the General Secretariat of the Conference of Constitutional Jurisdictions of Africa, has given a decisive impetus to this dynamic. Organized in a spirit of cooperation and solidarity, It brought together women magistrates from various African jurisdictions around a common goal to strengthen their role in consolidating the rule of law and promoting a more inclusive justice system. This meeting laid the foundation for a structured dialogue, promoted the sharing of experiences and good practices, and led to the adoption of the Libreville Declaration, which remains a reference framework for the actions undertaken since then. This meeting, the first of its kind in Africa, organized by the Conference of Constitutional Jurisdiction of Africa, and which was attended by no less than 30 African countries, aimed to create a framework for reflection on the obstacles that African women judges face in their career, and to reflect on the prospect of their development. To date, 49 of the 55 countries in Africa have adopted the protocol of the African Charter on Human and People's Rights on the Rights of Women in Africa, Maputo Protocol. This important regional human rights instrument calls for equality before the law and equal representation of women in judicial and law enforcement body, Article 8. This initiative has made it possible to analyze the representation of women in the African judiciary, identify legal, institutional, and socio-cultural obstacles hindering their professional progression, establish an institutional framework from reflection on gender issues in the justice system. The work culminated in the adoption of the Libreville Declaration, which recommend, inter alia, the creation of a continental network of African women judges. The CGCE now integrates the issue of gender equality into its resolutions, work programs, and scientific meetings. It acts in particular through the adoption of recommendations in favor of equal opportunity in appointment, raising awareness among member states of the challenges of women's representation, the promotion of women's leadership within constitutional courts. Since Libreville, the progress made is significant. In several African countries, we have seen significant progress and increased presence of women in higher courts, better consideration of gender issues in judicial decisions, as well as stronger commitment to equality within judicial institutions. Mentoring, training, and networking initiatives have been launched, helping to strengthen the capacity and visibility of women magistrates. This dynamic is part of an encouraging continental context. As of February 2026, Africa has 2 women ministers of justice, and at least 15 women serving as president or chief justice of their country's highest court. And we have 25 women who hold the position of vice president. This development reflects a significant increase in the presence of women at the top of the judiciary. In recent years, some African countries have taken steps to appoint more women judges and prosecutors at the national level. The number of women judges has increased considerably in African countries, reaching 50% of judges in some countries. At the regional level, at the African Court of Human and People Rights, out of 11 judges, 5 are women, including the Vice President of the Court, who kindly agreed to be present with us to share her experience. It is also worth highlighting the active participation of the Conference of Constitutional Jurisdictions of Africa in the event organized in New York on March 8, on the sideline of the 70th session of the Commission of the status of women. On this occasion, the CGC participated in this side event specifically dedicated to women judges, highlighting issues related to their role, independence, and leadership in judicial system. This presence on the international scene testify to the CGCA's commitment to bringing the voice of African women magistrates beyond the continent and to include their concern in the global dynamic in favor of gender equality. Ladies and gentlemen, however, despite this progress, many challenges remain. Women judges continue to face structural and cultural barriers. This includes gender stereotype, which will into question their authority and legitimacy, difficulties in accessing positions of responsibility, as well as constraints related to work-life balance. In addition, in some contexts, there are social and even institutional pressures that can hinder the independent exercise of their functions. It is also important to highlight the specific challenges related to safety, professional recognition, and equitable access to training and promotion opportunity. This reality reminds us that formal equality is not enough. It must be accompanied by concrete measures to ensure substantive equality. It is in this context that this second meeting is of paramount importance. It is an opportunity to consolidate what has been achieved, to deepen our collective reflection, and to define concrete strategy to meet the challenges identified. Our expectations are equal to stake. We hope that at the end of this work, we will strengthen support and mentoring mechanism of women magistrates, promote gender-responsive judicial policies, encourage state and judicial institutions to adopt measures to promote equal access to decision-making positions, consolidate our continental network to make it a real force for proposal and influence. The CGCE, for its part, plays a structuring role by mobilizing several complementarity levers to sustainability, improve the place of women in African judicial system by 1. The adoption of resolution and recommendation in favor of parity and equal opportunity, the development of a continental reference framework on gender equality in constitutional justice, the explicit integration of the principle of equality in the internal regulations of the members' courts, establishment of monitoring mechanism, creation of a continental observatory of gender, periodic publication of comparative data of the representation of women, definition of performance indicators measuring progress, training and leadership development, organization of specialist judicial leadership programs, establishment of a permanent network of women constitutional judges, development of intergenerational monitoring between courts, president, and young magistrate, dialogue with national appointing authority, cooperation with international organizations and academic institutions, promoting inclusive national policies, adoption of zero-tolerance policies against discrimination and harassment, establishment of confidential reporting mechanism, promotion of measures to promote work-life balance. For the period 2026 to 2028, the CGCE intends to structure in its actions around the following axes. 1. Integration of gender equality in the basic text of member courts. 2. Promotion of transparent and inclusive appointment mechanism. 3, institutionalization of the continental network of women judges. 4, strengthening of specialized training in judicial governance and gender-sensitive jurisprudence. 5, establishment of a continental observatory and publication of periodic report. 6, definition of measurable objectives in the short, medium, and long term. 7, integration of the gender perspective into constitutional jurisprudence. 8, launch of the African Grand Prize for Excellence and Leadership of Women Judges. This initiative is in line with the CGCA commitment to promote women's leadership within African judicial system. It aims to promote the exemplary careers of women magistrates and to strengthen their visibility on a continental and international scale. This Grand Prix has several strategic objectives. 1, recognize the professional excellence of women judges who have made significant contribution to strengthening the rule of law. 2, promote women's leadership in African constitutional and supreme jurisdictions. 4, encourage vocations and inspire the younger generation of magistrates. 5, create reference models capable of positively influencing judicial policies and institutional practices. Through this distinction, the CGCA intends to be beyond the simple symbolic recognition to establish a sustainable culture of value female merit in the judiciary. Ladies and gentlemen, before concluding, I would like to pay tribute to the remarkable work accomplished by the entire team led by my friend Jacob Jakes, who contributed to the preparation of this meeting. Their commitment, their rigor, and their sense of organization made it possible to give substance to this major event. Allow me to express my sincere thanks and warm congratulations to them for the quality of the work accomplished and for their essential contribution to the success of this meeting. I would like also to express my sincere thanks to the Chief Justice of South Africa and to all the judges and the staff of the court for the excellent organization of this conference, which was marked by great professionalism and the constant attention to details. I also express my deep gratitude to the hospitality and generous welcome extended to all the participants. This combined effort will greatly contribute to the success of this event and will create a pleasant setting to exchange and sharing. Finally, the symbolic choice of Nelson Mandela country to host this event has a strong significance, recalling the value of peace, dialogue, reconciliation, and solidarity that have marked his legacy and giving the conference a dimension that is both historic and inspiring. The CGCA plays a role as an institutional catalyst in the advancement of women judges in Africa. The aim is not only to increase women's representation in the courts, but to answer their real influence in constitutional decision-making and judicial governance. Ladies and gentlemen, let me conclude with the inspiring words from Nelson Mandela. It always seems impossible until it's done. May this conviction guide us in our common action. Before I finish my speech, I want to ask you that we have in Algeria, my country, an expression. We ask that only one hand cannot clap. If you want to clap, you must use two hands. I think we have also in South Africa a similar expression. It says that If you want to watch your hand, you must use two hands. Thank you for kind attention.
Thank you, Mr. Lara. This is yours? Thank you, Mr. Laraba. On behalf of the CCJA, at this stage, we are going to proceed to session 2. I'm not the chairperson of that session. I'm going to stand down now and hand over to my sister, the President of the Constitutional Council of Mozambique. Before I do so, let me just introduce her because she won't be able to do it. Ms. Lucia da Luz Ribeiro is the President of the Constitutional Council of Mozambique, having first been appointed in 2019 and reappointed in 2024. She has served as a judge of the Constitutional Council since 2003 and is one of the Mozambique's most senior constitutional jurists. Born in Maputo, she holds a law degree from Eduardo Mondlane University, a master's in business law from the Polytechnic University of Madrid, and a doctorate in law awarded in 2019. She's also a professor at the law faculty of the Eduardo Mondlane University. Justice Ribeiro is widely recognized for her leadership in constitutional justice in Mozambique and across Africa, and has represented her court in major continental and international judicial forums. I hand over to you, Chief Justice. Thank you. And they are here, for your people.
Bom dia, vou falar em português. Gostaria de começar por agradecer a Justice.
And then the other one is French also.
Thank you. I would first like to thank the director of program to allow us this opportunity and for the introduction about us that was done. English is channel 1. Can all hear me?
One song, please, whilst you are sorting out the problem. Thank you. Sorry about that.
English channel 1, thumbs up if you can hear me. Okay. Thank you. Once again, my greetings. I'll first start to greet Chief Justice Mandisa, and I'll extend my greetings all the Chief Justice in the room. I also would like to greet necessary difference our Justice Muslaraba, Permanent Secretary of CJA, Justice and here present, and all protocol observed. Making use of this opportunity for the first time in this second high level, I wouldn't like to leave behind to express my gratitude of the impact and honorable opportunity to be before you, this platform, in the quality of a moderator of this panel with the theme Judgment of Violence and Harassment Against Women. And secondly, I would like, in my name and on behalf of Mozambique delegation, I would like to thank, honestly, the warm welcome that is being presented to us since our arrival, that makes that naturally we feel ourselves at home. The distinct participant, distinct guests. A few days ago, we celebrated our International Day of Women, and in Mozambique, my country, we celebrated on the 7th of April, a Women's Mozambican Day, celebrating the power, resilience, and the way that the crucial Mozambican had in our society. The theme, the central theme of this panel that will talk about violence against women, this is a burden that affects all the levels of social and humanity. Today, in 2026, we need to ask ourselves why, with so many advancedly, the violence against women continues and in acceptable numbers. The answer of this is not only a lack of norms, but it's the challenge of its interpretation and applicancy. Most of the time, it's contrary or the stereotype of gender, which naturally impose violence, this harassment. That's why when we discuss the observance of Maputo Protocol in this theme, we will do emergency and hope. The emergency is guided by the data of the violence against women in the last years that demonstrate that although we do have our laws, the gender violence, femicide, and harassment is part of our daily life of millions of women. So the hope is presented to us, to each one of us that is here, that can be interpreted of the law as a shield to protect a woman and children. So the interpretation can be technical and profound, and that to reaffirm that the judiciary must be impartial, that will require to know all these equalities. The agenda of the theme is not only a technical platform, but this act of now silence and violence against women. Distinguished participant, because we here to hear the knowledge of our moderators, we honor and satisfaction I present to you. We will have, first of all, our moderator, Justice Ordia Naitikasi. Justice Naitikasi, it's
appointed in January 25, following a distinguished judicial career spanning more than 4 decades. Graduated of the National School of Administration in the judicial stream, she previously served as an advisor at the Council of the State and held a number of senior judicial leadership positions in Beja, Bondurets, and Bodia. She has also participated in the International Euromed Seniors on Judicial Cooperation, extradition, foreign judgment, and criminal laws. Mr. Knight Kansi brings to her current role deep judicial experience, strong institutional knowledge, and a long-standing commitment to the development of the justice session. Please, Justice, the floor is yours.
أيها السيدات أيها السادة.
Ladies and gentlemen, I would like to address every one of you in their name. Chairperson of the presenter of the program, thank you very much. I would like in the beginning, my colleagues, judges in African continent, and before I present my contribution in which I put my feelings as judge, as woman, for 40 years. I spent 40 years in the field, and before I start my contribution, I would like to convey to you the greetings of the President of the Constitutional Court of Algeria, Mrs. Saidawi. Our presence here today on this second high-level meeting for African women in justice. It is not just participation. It is a response to a necessity which imposed by our aspiration, our joint aspiration, and our things cannot, our society cannot prosper if there is marginalization and fear. My intervention on the issue of violence against women and harassment, it didn't require me much. Which is what automatical. Allow me today to share with you my experience, because I'm a judge and I'm a human being before I become a judge or a member in the Constitutional Court of Algeria. Every time that I visit the grave of my mother, I cannot forget that beside her there is a grave of an Algerian woman who was beautiful and very ambitious, who was looking for a better life, but her journey ended with disaster as she was killed, burned by her husband. Her name's Shahinaz. In my memory as a judge, and through many years in courts, Algerian courts, I still remember the features of a woman in her 40s and a mother of 4 children who endured daily tortures, and she was afraid. And she was afraid to declare or to announce it, and also she ended in disaster as well. So through these painful stories, which are many, I can stay with you for the whole day telling you all these stories. However, there is one reality. I have deducted it from my experience, that violence is a phenomenon that does not recognize sex or boundaries or time. For these women, and because silence is no more an option, so the Algerian constitution in its amendment in 2020, and this is a pride for us, it has turned balance of power and established new guarantees in the area of protection of freedoms for all citizens, and especially women, Algerian women. Article 40 of the Constitution, it was not just a legal addition, but it was a commitment, a national commitment, and a commitment that says that protection of women in her house and in her work, and it is a responsibility of the state, and there is no retreat from that. In Article 40 of the Constitution, it is not an ink on paper, but it has become a national commitment that imposes on the country protection of women in her work, in her house, and on the street. And I would like, on this occasion, to appreciate highly this milestone, constitutional milestone, that established guarantees and enough protection, and protection that empowers women and enables her to play her role with confidence in society. And the legal system, the national legal system, has emphasized it. And because real protection requires a strict law, the new amendments in the penalty laws has come with very clear wording that cannot be misinterpreted. First of all, recognition of the psychological violence. For the first time, the Algerian legislature admits that the wound that is invisible is a crime. The psychological violence that undermines dignity is a crime. So there is no tolerance with the marital violence. Number 3, elimination. The digital space is not safe for violators. Harassment on the street or through internet, or intimidation through special pictures are crimes that might reach to 10 years sentence, and protection of the victims, and also the perpetrators are prohibited to approach the victims. Today, the law protects the independence of women and strictly punishes any kind of violence by a husband, and any husband that tries to take his wife's salary will be punished. Today, also the pregnant woman is well protected, and also the victims of trafficking are also punished. Ladies and gentlemen, impunity is gone. The time of impunity has gone. The Algerian constitution has emphasized this principle when it comes to the issues of violence. However, when the tolerance and forgiveness is part of the society, and it might lead to prevention of litigation, but that is not the case if it lead to permanent injury or death. Accordingly, forgiveness or in crimes cannot allow impunity, but it is just it mitigates the punishment, which is a legal shield that protects women from family pressures, which use to oblige her to abdicate her complaints and forgive the perpetrators. And this and this also guarantees the state punishment. Ladies and gentlemen, in order to face the phenomenon of violence against women, the state has moved to from punishment to support and to accompany the women to have a comprehensive system that compensates women in difficult situations. So the national centers provide a comprehensive care, including shelter and psychological follow-up, vocational empowerment, and all kind of empowerment. And also, these efforts culminated in 2025 in digital mechanisms, which is the Green Line 2010, and also application of guarantee of immediate reporting, and also a platform for family consultations, and also some guidance and legal guidance that aim to empower women and facilitate her access to her rights in a way that guarantee a constitutional immediate response to all kind of women concerns. And lastly, and in my capacity as a judge, I always concluded the sessions by announcing sentences. And today, on this platform, and in front of all of you, I would like to say that our rule as societies, the rule has been issued, and this is a final rule that cannot be repealed. Our dignity allows no any kind of compromise. Our states do not draft legislations to provide justice for the victims of yesterday only, but also to protect the women of our future. We build this legal arsenal in order to protect every woman, and so that no woman should stand in front of the grave of her mother to recall any kind of bad memories. And today we are here to open a new page to protect the life of all the women in the world. Violence was yesterday, and it is still today, but we hope that this forum, this special forum for women in justice, that we come up with ambitious recommendations that protect women from all kind of violence, and also draw a prosperous future for the women of future. Thank you very much for listening to me.
Muito obrigada.
Thank you so much. Thank you so much. Thank you so much for your presentation and the experience that you have lived in your country, as well as to bring concrete examples. We really lament that tragic experience. However, the law against the women, in other words, violence against women, it is a reality in these days. I won't sum up, given the time that is against us. We are going to pass to the next presenter, Antonia Guava.
Honorable Justice Antonia Guava is the senior judge of the Supreme Court of Zimbabwe and one of the country's most experienced appellate jurists. She was appointed to the Supreme Court in 2013 and early served on the High Court branch. In addition to her judicial work, she has played an important mentoring role within the judiciary, including addressing newly appointed judges on the court preparation and the case management. Justice Guvava has also spoken publicly about the significance of women judges in strengthening to the justice system and inspiring future generation of women lawyers and judicial officers. Please, Justice, the floor is yours.
Thank you, Madam Chair, for the kind introduction. The Honorable Chief Justice of the Republic of South Africa, Justice Meyer, and all the Chief Justices here present, allow me to ride on the protocol which was established this morning at the opening ceremony. It is indeed a privilege and an honor to be invited to contribute in a small way to the second high-level meeting of women judicial officers. The theme and the topic which we have been asked to speak about, in my view, is of particular importance to each and every one of us. This discussion is centered on the global movement on the continued fight against domestic violence and harmful practices through the justice systems. An analysis of this adjudication system must be carried out through the lens of constitutionalism, regional and international human rights obligations, and evolving judicial responses. It is noted that different countries and international and regional organizations have adopted different strategies to address issues of domestic violence and harmful practices against women. From the Zimbabwean perspective, there's been an ongoing strong normative framework for the protection of women's rights through constitutional intervention, judicial precedent, and legislative transformation and government policies. It should be noted from the outset that as a jurisdiction, the Zimbabwean criminal law does not recognize the crime of femicide as a distinct offense. Instead, cases that come before the courts involving the killing of women, often by their spouses or intimate partners, are typically treated as manifestations of domestic violence within the family context. Such matters are characterized under murder or culpable homicide, as provided for in the Criminal Law Codification and Reform Act. In this regard, this discussion will focus on the impact of domestic violence and harmful practices on the rights of women in Zimbabwe and how the government of Zimbabwe and the courts have been instrumental in guarding against these societal menaces. We have been advised by the chairperson that we should strictly stick to the time which have been provided, which is barely 15 minutes. So what I intend to do is to skip quite a bit of my presentation, which was covering the international and regional instruments and the Constitution of Zimbabwe, and how it impacts on the domestic legislation in Zimbabwe for when dealing with domestic violence and harassment. The basic legislative framework in Zimbabwe, that is the statute which deals primarily with domestic violence, is informed by the International Convention, the CEDAW, the Maputo Protocol is a regional instrument, and of course, the Constitution of Zimbabwe. The act is known as the Domestic Violence Act. This act defines domestic violence as an unlawful act, omission, or behavior which results in death or the direct infliction of physical, sexual, or mental injury to any complainant by a respondent. The section goes on to list various examples of forms of abuse, which include physical abuse, sexual abuse, economic abuse, emotional, verbal, and psychological abuse. I should pause just briefly to indicate that the Act does not criminalize emotional, economic abuse, and psychological abuse. I'm sure it was crafted by men. Of interest is Section 3(1)L of the Domestic Violence Act, which sets out harmful practices under the definition of domestic violence as follows, and I open quote, abuse derived from the following cultural or customary rights or practices that discriminate against or degrade women. And they set them out as follows: forced virginity testing, female genital mutilation, pledging of women or girls for purposes of appeasing spirits. I don't know whether it's still all over the world or just in Zimbabwe. Forced marriages, child marriages, forced wife inheritance, sexual intercourse between father-in-law and newly married daughters-in-law. This is an issue which is dying down quite a lot, but it was being carried out in a section of Zimbabwe where the first sexual intercourse that a newlywed woman would have would be with her father-in-law. The supporting legislation in the fight against domestic violence is to be found in the Criminal Law Code, which criminalizes various forms of assault, sexual offenses, and related conduct. The Criminal Law Code addresses domestic violence by criminalizing the various forms of abuse that commonly arise within domestic relationships. These include physical violence, which we all know the assault, which are prosecuted as assault, the sexual violence offenses, which are prosecuted under rape and indecent assault, and femicide, which is prosecuted as murder or culpable homicide. We find that generally in the courts, the prosecution does not ordinarily charge persons under the Domestic Violence Act. They tend to lean more in terms of the code. But we found that generally when magistrates who deal with these matters on a daily basis, when they deal with these matters, they seem to interpret them and deal with the Domestic Violence Act as when they deal with the actual cases that appear before them. Because the acts itself or the statutes do not really assist victims of sexual violence, the government of Zimbabwe saw it fit to introduce sentencing guidelines. These guidelines have been were introduced in 2023 as regulations under the Criminal Procedure Act. These were informed, I think, primarily with the question of sentencing of cases which relate to domestic violence and, of course, other offenses as well. So if I give you an example of, for example, a male judicial officer who, God forbid us, assaults his wife regularly. The following morning, he has just assaulted her the night before. The following morning, he walks into his courtroom, and lo and behold, there is a respondent before him who is being charged with domestic violence, having assaulted his wife. What kind of sentence do you think he'll give? Penalty of a fine? So in order to take away that discretion that judicial officers would have, the sentencing guidelines were introduced. These provide presumptive sentences for various offenses. For instance, for the crime of murder, there'll be a presumptive sentence of 20 years. Then depending on whether or not there are aggravating circumstances, it can go up to life imprisonment. We recently abolished the death penalty. We do not have it. And it goes on with other instances such as assaults, which would carry a presumptive sentence of about 12 months. I move on quickly to a case which was decided by the Constitutional Court of Zimbabwe, which was dealing with child marriages. It's known as M versus Minister of Justice. In that case, it was a landmark judgment by the Constitutional Court. The Constitutional Court struck down a provision in the Marriages Act which allowed a girl over the age of 16, but under the age of 18 to get married. So following the striking down of that provision, a new Marriages Act was introduced, and this act does not allow for persons to be married who are under the age of 18. And importantly, it creates an offense for guardians who allow children who are under the age of 18 to be married. The system has also noted that in the courtroom, especially for vulnerable witnesses, that is your children who have been abused or raped, women, the system does not really look after such victims. So as a result, what is known as a victim-friendly system was introduced. This is a system which introduces units at different levels, for example, at the police station, in the courtroom, and at other spheres in the hospitals, and at the social welfare level to assist victims of abuse. At the police station level, the police officers who deal with women or children who have been subjected to domestic violence are trained officers. Every police station must have a unit which deals with such cases. The police officers who man these specialized units receive specialized training on the offenses of domestic violence. They offer private and confidential reporting environments and also offer counseling and referral services. I don't know how many of us have walked into a police station and you want to report a crime. And there's a large group of people who are there, people who have been arrested, a large group of police officers, and they call out, "Next!" And what do you want to report? I was raped. Please speak up, we can't hear you. I'm sure we've all experienced that, or we have had clients who have experienced that sort of experience. And you can imagine that is why a whole number of women prefer not to report cases of domestic violence or cases of rape or indecent assault. So at the police station level, you are able to ask for the special unit on domestic violence, where you can go and report your matter in private. We also, the government of Zimbabwe also introduced what are known as victim-friendly courts. These are courts which were introduced under the Criminal Procedure and Evidence Act of Zimbabwe, and they are designed to protect women and vulnerable witnesses when they give evidence in court. The witness, especially children who have been abused or women who are vulnerable. At the moment, I think we've got a case which is going on in Zimbabwe where a very powerful prophet is being charged with rape of several women, and they are afraid to give evidence. And an application has been made by the prosecution that they be treated as vulnerable witnesses so that they can give evidence away from the accused person, where they do not have to be in direct contact with the accused person. For children, they actually use animated dolls for them to explain what has happened to them if they've been raped or indecently assaulted. And they use an intermediary who will assist the child and give support of any kind. I know I'm running out of time, but I thought that I should just quickly deal with a few cases which have been determined by the Zimbabwean courts, where the application of the Domestic Violence Act has been taken into account. In a case in 2012, you will receive a copy of my presentation, so you'll get the citations. The court indicated that it was imperative that the courts impose deterrent sentences on persons who have been convicted of domestic violence. And I'll just quote just a piece of what the honorable judge said. I'm of the view that unless sufficiently deterrent sentences are imposed by the courts as provided for under the Act, the whole purpose of this piece of legislation will never be realized. Men will continue to brutalize their wives, and equally so, men will continue to be subjected to physical abuse by their spouses, in the knowledge that they will go to court and pay a small fine. The second case, which I just want to refer to you quickly, is a case of the state versus Ganga. This case was determined by a female judge. The matter had been referred to her on review from the magistrates' court. These are the courts that generally deal with these matters. And looking at the Domestic Violence Act, she accepted that the unique objective of the Act was intended to preserve and restore family unity rather than to contribute to its breakdown. But this lady judge then went on to say, but this man, he has not done it once, he has done it before. So he should be sentenced to a term of imprisonment. So she upheld the sentence of imprisonment which had been imposed by the magistrate. And because the case was such a silly case, the wife had refused to have sex with him. So he beat her up. So he was sent to prison. Finally, before I conclude, I just want to deal with the challenges that are faced by adjudicators. So in spite of the robust legal system aimed at addressing domestic violence and harmful practices, several structural and operational challenges continue to impede their full eradication. The geographic distance from courts and police stations, especially in the rural areas. I will not go in detail because we have we are trying to deal with that in the sense of the integrated case management system, which allows us to hear evidence from persons even when they're away from the courthouse. But it is still a major issue, especially in the rural areas. The limited availability of legal aid in some areas. Whilst each courtroom has tried to provide legal aid for persons who require it at the courthouse and to give legal assistance, they cannot do it in every courthouse. So that also prohibits the assistance that can be given to women. But the major issue, which I just want to dwell on quickly, is the socio-cultural norms and socio-cultural norms and patriarchy remain significant barriers to the eradication of domestic violence, as they entrench unequal power relations and normalize abuse within intimate relations. In many communities in Zimbabwe, patriarchal values position men as dominant and women as subordinate, fostering beliefs that justify control, even violence, as a form of discipline. So in spite of the strides that have been made by such things as CEDAW, the Maputo Protocol, the Constitution, which goes to town about equality of women and that there should not be violence, these things are still entrenched. There is also the problem of customary dispute resolution mechanisms and certain religious or traditional interpretations which may prioritize reconciliation over accountability. Whilst they are good in many respects, but in some instances, one would like venture to say that it is necessary that criminal remedies are brought into play. This obviously then results in the problems of underreporting of domestic violence matters and the withdrawal of cases. Then for child marriages, there's a phenomena which has come up of collusion. That is where the parents of the minor child and the perpetrator collude to hide the offense. And as a result, the abuse on child marriages is not reported. Recently, we had a very sad instance where prophet or someone from a religious group had a whole lot of, was gathered in a camp, and someone then informed the police that there were a number of shallow graves which were in the area because children who were under the age of 12 had been married off and they died during childbirth. So there was no reporting, there was nothing except the skeletons of these little children. Finally, Madam Chair, yes, I will conclude and say domestic violence and harmful practices remain deeply entrenched in Zimbabwe. The persistence of these violations reflects the gap between normative commitments and practical enforcement. The judiciary, therefore, has a critical role in bridging this gap by adapting to a transformative, rights-centered, and gender-responsive approach to adjudication. This can be done through rigorous training of judicial officers so that they are sensitive and fully appreciate the demands placed upon them when they deal with such matters. I would also add that the training should include the use of the various international and regional instruments in their judgments so that these issues come out. This might be done through workshops and conferences such as this one. I'd venture to add that training should not just focus on female judicial officers, but also on their male counterparts. In this way, we can ensure that there is full implementation of the Maputo Protocol and other international instruments in our jurisdiction. In this way, we as the judicial leaders of this generation can ensure that there is full implementation of the Maputo Protocol and other instruments in our jurisdictions so as to protect future generations, our children and our grandchildren, from this scourge of domestic violence and harmful practices. I thank you.
Muito
Thank you very much, Justice Anton Gubava, for the rich explanation. She brought here a draft of legal action in Zimbabwe that still have some gaps, and above all, when there's no penalty issue of psychological violence, which is harassment, and economic. Also brings the challenge of norms and strategy of prevention. I think we'll have an opportunity to have some debate. Due the time, I'm now inviting Justice Zukisa Tsiki,
National Court of South Africa, and a jurist of extensive experience across legal practice and the superior courts. She practices as an attorney for 40 years before joining the branch in 2005, and later served as a judge of the Supreme Court of Appeal from 2009 until her appointment to the Constitutional Court in 2019. Justice Tsitsi holds a B process degree from the University of the Witwatersrand and an advanced diploma in labor law from Rand's Afrikaans University. She is also recognized for her work in constitutional transformation, judicial training, and human rights advocacy. Please, Justice, the floor is yours.
I'm sorry, I may need to, now and again, to cough. I don't know why this cough is embarrassing me. I'm not fluish, I think it's old age. I have an irritation on my throat, so you'll forgive me. Good afternoon, ladies and gentlemen, distinguished guests. I hope you are now settled in South Africa after yesterday, where we were forced to do what we ought to do on a daily basis, give ourselves a break and rest. But we managed to do that yesterday. And thank you to my colleague, Judge Mia. Ladies and gentlemen, thank you for the kind introduction. All protocol observed. Thank you, Justice Kachi and Justice Gubava, for your insights into the Zimbabwean and Algerian contexts. I hope to add to the conversation by offering some reflections on the progress which has been made in advancing gender equality through South African courts. I will begin by discussing 5 seminal cases that have shaped and developed our jurisprudence on women's rights. Before turning to the first of these cases, it is useful to situate these developments within the broader constitutional framework. Since the advent of our constitutional democracy, South African courts have played a pivotal role in giving substantive content to the rights of equality and dignity, particularly in relation to women. The cases I will discuss illustrate how these principles have been interpreted and applied in concrete contexts, often reshaping the legal landscape in meaningful ways. The first of those cases, the case of Coko, spelled C-O-K-O, a criminal matter concerning the offense of rape. In this case, the complainant had repeatedly communicated to the accused that she wished to remain a virgin. The complainant agreed to spend an evening with the accused, but made it clear that she did not want to have penetrative sex. As the evening progressed, the complainant did not object to kissing the accused or receiving oral sex from the accused. Subsequently, the accused initiated penetrative sex with the complainant, despite the complainant's persistent, earlier communicated commitments to remaining a virgin. The High Court took a troubling approach to the case, disregarding the complainant's commitment to retaining her virginity. Her continued objections, including the objection just prior to the accused removing her clothes, and the lack of express consent. Instead, the High Court seemingly inferred that the complainant's participation in other intimate acts justified the accused's subjective belief that tacit consent may have been given to penetrative sex. The High Court's decision was overturned by the Supreme Court of Appeal, headed by my sister, President Mulimela. Well, it was not on my notes, I just saw you and was tempted to mention your name as my sister, because this is a very important judgment from your court. The Supreme Court of Appeal criticized the lower court's findings that the complainant was an active participant because she did not object to a number of activities performed by the accused, that no force was used, and that there was no coercion. The Supreme Court of Appeal observed that the High Court had, I quote, clearly played into the myth that a man can take consent to one sexual act as an invitation to perform all other sexual acts, and that going with the moment is an acceptable defense, which is not. That the Supreme Court of Appeal made clear. The Supreme Court of Appeal further confirmed that mere submission or acquiescence or lack of resistance does not convey a willingness to engage in a penetrative sexual act. The decision delegitimized several pervasive rape myths and reinforced the need for active consent in sexual relations, strengthening the rights of women across the country to dignity, bodily integrity, and equality. The second case I wish to share with you is Jordan versus Minister of Home Affairs, which concerned the constitutionality of legislation which provides for individuals to change their names. The legislation did not provide for men in heterosexual marriages who wanted to assume their wife's name to do so, nor did it provide for parties in same-sex marriages or civil unions to do so. The High Court declared the legislation unconstitutional on the ground that it discriminated on the basis of gender. An application was brought to the Constitutional Court seeking to confirm this declaration of invalidity. The question for the Constitutional Court was whether this legislation was incompatible with the right of equality under Section 9 of the Constitution, that is the South African Constitution. In reaching its decision, the Constitutional Court observed that, I quote, in many African cultures, women retained their birth names after marriage, and children often took their mother's clan name. In parts of Africa, the tradition of a woman assuming her husband's surname is rooted in colonialism, religion, and patriarchal cultural norms. With the arrival of the European colonizers and Christian missionaries and the imposition of Western values, the tradition of women taking their husband's surname was introduced. This practice reinforced patriarchal norms where women were seen as subordinate or legally inferior, akin to a minor in brackets, to their husbands and expected to assume their identity, I close quote. I'm sorry, I want to make sure that my notes are okay. The Constitutional Court found that the differentiation based on gender in the legislation discriminated against both men and women. For men, they were deprived of the ability to take their wife's surname if they wished to do so. For women, the effects were far more insidious. The legislation reinforced patriarchal gender norms, which prescribed how women express their identity and made this expression in relation to their husband as a governmental and cultural default. The court found that this limitation of equality could not be justified and confirmed the unconstitutionality of the legislation. This decision may reasonably be described as a landmark decision on the continent for its progressive realization of the right of equality and its sharp critique of enduring patriarchal structures. We were criticized a lot about this. The question I posed to our critics is whether the courts are expected to impose their views on young couples who wish to arrange their marital affairs in a way that is not offensive, but which they have chosen for their lives, and also which does not offend any constitutional principles. The remaining cases that I want to share with you may be considered together, since they all concern the institution of marriage and the protection of women's rights to property in that context. These are three constitutional cases: the case of Ramohovi versus President of South Africa, the case of Sithole versus Sithole, and the case of VVC versus JRM. In Ramohovi, which was decided in 2017, the Constitutional Court held that the default matrimonial property system for polygamous marriages entered into prior the enactment of the Recognition of Customary Marriages Act, namely that they were out of community of property, amounted to unjustified discrimination based on gender. The court found that the provision perpetuated inequality between husbands and wives and limited the rights to dignity and non-discrimination. Then the second case, that is Sithole, decided in 2020, the Constitutional Court held that legislative provisions which maintained that marriages of black couples entered into before 1998 were automatically out of community of property was unconstitutional. The judgment recognized the vulnerability which arises for women from their traditional role as bearing responsibility for housework and childcare, which means they are less likely to be employed than men and therefore less likely to own property in their names. Finally, I wish to share the case of VVC, decided in 2026. As a background to me sharing this case, I want to share that in our country, specifically in the African communities, black communities, young couples who cannot afford celebrating their marriage properly, like a big wedding and all of that, often opt to start with the traditional practices so that they can then conform to the custom, so that the wife is recognized by the family and all of that. So you find that lobola is paid, and when that negotiation process is finalized, you find those couples getting married through customary unions. When they are able to afford, they then decide to celebrate their marriage through a very elaborate wedding. But unfortunately, in that process, they again enter into civil marriages. So in this case, our court was faced with that dilemma, because before they entered into the civil marriage, this couple entered into an antenuptial contract. Now, an antenuptial contract should be a contract entered before marriage. So they were married before through custom. Now they enter into another contract before concluding the civil marriage. And in our country, customary marriages are recognized to be equal to civil marriages. So now this couple is getting married again. And the issue that we had to determine is whether that antenuptial contract, which unfortunately then said the marriage is out of community of property. When they entered into marriage through custom, the marriage was in community of property, because that's what the law says. It makes customary marriages in community of property. Now they are married by civil rights, and before they do so, they sign an antenuptial contract, which then said that they are now married out of community of property. So that was the dilemma that we had. The Constitutional Court found that where parties enter into a customary marriage and then subsequently enter into a civil marriage and conclude an antenuptial contract, in terms of which the civil marriage would be out of community of property, the customary marriage is not dissolved, and the later civil marriage subsumes the customary marriage. It held that the contrary interpretation would entrench the historical discriminatory position and would be in conflict with the constitutional recognition and status of customary law. So, yes, a lot of people in South Africa, specifically black couples, are involved in this. So this created a lot of interest amongst the public, because they were now asking, because for them, they thought that if you are married customarily, you don't have the status of people married in civil marriages. So it was sort of a culture shock, but I liked that because it made people think and realize. I think through this judgment, people realized that in fact customary law marriages are marriages as well, and that you do have rights, even if you are married customarily. Because other people thought that if you are married customarily until you conclude a civil marriage, you are not really married properly. But I think that this case created an awareness now to couples that customary marriage is marriage, and it has got similar rights to a civil marriage. This series of cases represents a sustained recognition by the Constitutional Court of the vulnerabilities and systematic disadvantages faced particularly by black women in marriages outside of community of property. As I observed in Sithole, I quote, "Societal dynamics such as patriarchy, gender stereotyping, inflexible application of oppressive cultural practices perpetuate the intersectional consequences of forms of discrimination against women with dire consequences. It is therefore one of the main drivers of the oppression of women through gender stereotyping and the abuses of cultural practices. These dire consequences have rendered women vulnerable, and this vulnerability is an aspect of social reality," close quote. I now turn to consider some of the other ways that South African courts have developed and advanced women's rights outside of their judgments. One significant development was the adoption of a comprehensive sexual policy by the South African Judiciary in 2025. Sexual harassment in the workplace represents a violation of many of the fundamental values upon which our democratic state is founded. It undermines the health and safety of our judicial working environment, particularly for women who are disproportionately affected by sexual harassment. It also threatens the foundational legitimacy and integrity of courts as the custodians of the rule of law. The sexual harassment policy reinforces the judiciary's commitment to the constitutional values on human dignity, equality, and justice, and sends the clear message that sexual harassment has no place in the halls of justice. Adopting a victim-centered approach, the policy enforces zero tolerance for sexual harassment by or against any judicial officer, staff member, or individual engaging with the judiciary. It establishes the gender desk in the Office of the Chief Justice to receive reports, requests for informal resolution, and complaints of sexual harassment, with clear, confidential, and fair procedures for reporting and addressing complaints. The policy also requires every judicial officer to complete anti-sexual harassment training prior to appointment. Through these mechanisms, the policy helps to promote women's rights within courts which are clear, ultimately workplaces like any other, where women's rights are promoted within the courts. The final example I will mention briefly is gender equality amongst judicial officers. Well, the Chief Justice touched on this. With the recent appointment of Justices Dambuza and Savage to the Constitutional Court, the court has become one of the very few women majority apex courts in the world. More broadly, the South African judiciary has undergone a remarkable transformation in terms of gender representation. At the end of apartheid in 1994, there were only 2 women judges in South Africa out of a total of approximately 165 judges. In 2025, the percentage of women judges was almost equal to men, standing at 48%. One of the ways that gender inequality within the judiciary is facilitated is through Section 1742 of the South African Constitution, which requires that the racial and gender composition of society be considered when appointing judicial officers. A gender-balanced judiciary ensures that the legal system reflects the society it serves, ensures that the issues such as discrimination and gender-based violence are adjudicated from a place of understanding, and strengthens public confidence in the legitimacy of the courts. I hope that I've managed to illustrate how courts can make significant advancements in women's rights through their judgments, internal policies, and judicial composition. I should say that the example I have provided by no means mean that our work on gender equality in South Africa is done. Gender-based violence remains a huge problem in this country, and the courts will no doubt be seized with matters touching on different facets of gender equality in the future. It is also important to recognize that the courts are just one vehicle through which the women's rights can be advanced. Change must also take place at societal level in terms of shifting attitudes and undoing patriarchal legacies. I firmly believe, however, that where courts can set an example of exemplary gender equality, this can diffuse into a society and be the catalyst for more widespread positive change. That is the end, and ngiyabonga, thank you, danki.
Thank you very much, Justice Zuki Satsiki, for your brilliant presentation and also to share with us the presidency of your country. We had the context of 3 countries, Algeria, Zimbabwe, and South Africa, and I think now it's now acceptable to say that our honorable speakers and their own experience or working experience, they brought the working experience and life. They brought here for us the studies or presentations that were clear and straight to the point, that allowed us to understand, that we could be able to have some reflection for our debate. But due the time that we were supposed to start in the next panel, we will try our best to be specific and brief in this debate. We'll leave that. We'd like to see that the presentation will take less time due to this presentation of this kind of jurisprudency. Is an interesting aspect, so that can allow us to understand the draft on legal draft of constitutional of each country, development of each country, the strategy of prevention against the fight against the women rights or gender-based violence. We'll go straight and open the platform. Maybe we can limit 2 or 3 interventions because this theme will be touched again. It's transversal in all the panels. So all that we have to share with us, those who won't be able to can talk at a late stage. I can see one. Favor, each one of you can introduce themselves so that we can also know who we're dealing with. And I thank you.
Chairperson, I'm Toba from KwaZulu-Natal in South Africa. Thank you to all the presenters for their insightful presentations. Mine is directed to Justice Antonia Kuvava from Zimbabwe about that judge that was assaulting his wife. What happened to him, and do you not have anything in your judicial code that deals with the judges that offend the law, particularly in such circumstances? Thank you.
Thank you very much for that question. And I sincerely apologize if it came out wrong. It was just an example to introduce the guidelines, the sentencing guidelines. So I was just saying, if for instance you have a situation where there's a male judicial officer, then what kind of sentence would he give? So it was not something that is happening. Thank you.
Please, we have 2, a
Yes.
Swatini and another one. Yes. Now is the Swatini first.
Thank you, Chair. Quickly, Justice Tiki, may I find out from the last case that you discussed, what was the decision on the proprietary rights of the parties? Which regime among the two, the customary and the civil marriage, which governed the parties' proprietary rights? Because both were upheld to be valid and effective.
Let me clarify. As I said, this couple was married before in terms of custom, and now they purported to enter into an antenuptial contract and concluded a civil marriage. It's a very interesting judgment because the effect of it is that that civil marriage was invalid because the customary marriage was a valid marriage, and this couple did not get divorced. So 2 principles. The customary marriage was valid because the couple never ended that marriage. So it was still in existence. And their proprietary arrangement was that it was a marriage in community of property in terms of the customary Marriage Act. And therefore, because the civil marriage was invalid, then they could not enter into a contract which they said it was an antenuptial contract. Because an antenuptial contract by its very nature is a contract that you conclude before you enter into a marriage. So they were already married when they entered into the antenuptial contract. So that contract was not an antenuptial contract, but it purported to be, but it fell away as well until they did something about the customary marriage. Thank you.
Merci pour la parole. Je suis...
Thank you for the floor. I'm
Madam Zeba from DRC. I would like to contribute on the resistance, on the tradition or our culture in Africa, on the challenges judges are facing based on what Madam the President just said. In my country, there is a pastor in jail who has married a lady of 15 years old, and the judges has condemned the father of the lady and the pastor, just to say the judge should not retrieve herself or himself, and he have to give a judgment that is really firm and also socially explained, because within his motivation things have to change. In that case, everyone who will maybe be tempted to marry a minor will now think twice, because that decision has changed things for the future.
Thank you very much. It's not a question, but no? Please. We have more on.
Yes. Thank you. I wish to go back to Justice Seke, and in relation to your answer to the question concerning the couple who first had an unregistered customary law union and then sought to have a civil marriage, but before that entered into an antenuptial contract. My question is that are couples who start off with a customary union, are they forbidden by law to upgrade their marriage? Or if it's upgrading, I don't know. In Zimbabwe, it would be upgrading because there are more benefits there. Upgrade to a civil marriage. Would they have to divorce first in terms of customary law before they can contract a church marriage, for instance?
Basically, this case became tricky, and it is tricky, and I'm not surprised a lot of questions come out of it, because earlier, before democracy, African marriages that were conducted or concluded in terms of custom were not recognized as marriages. So what happened then was that they were then made equal to civil marriages. I don't know whether it is because when we were deciding this case, I thought that, this comes from the past, the apartheid years. Some people are aware that customary marriages are equal to civil marriages. Some people are not aware. So in a way, I felt when we dealt with this case, some people, it's a practice people were used in the past to thinking that if they concluded customary marriages only, they were not really married, and would then conclude the civil marriages to be married. But that practice of now concluding two marriages by African couples, it just continued. Now, back to your question. Your question is whether people are not allowed to marry. People can celebrate their marriages in church or at home or wherever they want to be, as long as they are aware that they're already married through custom. So you just need to be aware before you celebrate, so that you don't think that when you conclude a civil marriage, you are being married for the first time. You are not married for the first time. And before you can conclude that civil marriage, you then have to end the customary marriage But if you don't do that, you are free to celebrate. And we do it. We go to church in front of a priest. The priest knows that you are married, and the priest would then be said to be blessing the union. So the technicality becomes when people think that they are getting married for the first time. And that is the problem that we have. And in our country, even if you are married by custom, there is no law that says that this is applicable to customary marriages, to end customary marriages. Because they are equal to civil marriages. There's no special dispensation for ending that marriage. Thank you.
Obrigada. Obrigada.
Just to add to what Justice Tikwe said, I think what happened in this case, the husband wanted to divorce, and she wanted to make sure that the wife does not get the property. And that's how this civil union came in, and this anti-nuptial contract. We said in that judgment, if you want to conclude an anti-nuptial contract, it's no longer an anti-nuptial contract because they're already married. It's a post contract. And you cannot do that. The only way that you can do so, you must approach the court. And in this particular case, they never went to court. She just took her and then signed and then said, now we are married out of community of property. So we said, you cannot do this because you are already married by customary union in community of property. If you wanted to be married out of community of property, you should have said so when you concluded that customary union, because even in that one, you may indicate that you want to marry out of community. If you don't say so, by default, the marriage is in community of property. Yes.
Muito obrigada.
I'm not the chair, sorry.
Sorry, Chair. Just to add.
Bom, parece que não teremos muita possibilidade. Vou passar.
I think we are not having more possibilities here. I can see about 10 hands raised on air for intervention. We will just entertain 2 more people because this theme is quite interesting. And to say that in Mozambique, the law allows that the customary union and religious can be transcribed for the civil union without the need of terminating a marriage, for example, a traditional marriage, just so they can consider a civil marriage. However, what happens is the following. Even though the law allows people prefer to celebrate religious marriage, the following day they go for civil marriage. Some they even go to the extent of going traditionally. Therefore, we are invited to 3 and 4 for just one matrimony. And to economize time and money. They should opt in one marriage, then they would embark on other civil marriages. This is in all people. And I remember that the child of a justice minister was marrying. When he came to the church, the bishop said, we are going to celebrate this marriage here. Then after, we are going to civil matrimony. You should set the example that when we celebrate here in the church, they will take this marriage certificate to civil marriage. Maybe the law is more divulged or we don't want to apply. Should you get married in the church, the following day they can take the marriage certificate and they will consider in the civil manner. Then let's go to Gabon.
Thank you very much. I'm Akfikita Ngonju from the Constitutional Court of Gabon, judge in the Constitutional Court of Gabon. My question is to Judge Kisa, who told us about a case that is very interesting concerning customary marriage. Now, I would like to understand, in South Africa, those who are married according to customary law, do they have the same status as those who got married in front of the civil officer? Does customary marriage have the same legal effect as the civil marriage? Because in my country, in Gabon, we acknowledge in law only one marriage. It is the marriage that before the civil officer, simply because customary marriage does not have any legal value or social legitimacy, for the mere reason that when you are going to ask to marry a Gabonese girl, the father of that girl is firstly going to ask you to marry his daughter. Customary comes to South Africa. What is really? Can we get married in a civil state and according to the customary laws as well, and go from one marriage to another with the same legal effect? Or do we only consider one marriage? Because it seems like what I understood here, since that decision that was given by the court, customary marriage now has become a civil marriage. Now, I didn't understand that very well. I just want to get some clarity regarding that. Thank you very much.
Elaborate on our past, how African marriages were treated, and how the customary marriages were not recognized. So after democracy, because we all got married, we knew that we had to go to the office, to Home Affairs to get married, but there are certain sectors of our community in South Africa who live through custom and who live through traditional practices. And most African people do. And we are different ethnic groups. But the one thing that we all do is that before we enter into customary marriages, we would pay lobola. There would be negotiations which are aimed at growing relationships between the two families and all that. Now, before democracy, those marriages, irrespective of all those practices, were not recognized. So the legislature decided to validate customary marriages. That's why we have civil and customary. Because in the past, if you are married through custom, one, women were not protected. So women would not have a claim to the matrimonial property. Secondly, a man would just leave you. So that was unacceptable. So there are not two marriages that coexist as such. There's only one marriage. It's either you are married through custom, or you are either married or you are married in civil rights. So personally, for instance, I'm married through civil rights. And there are a lot of other Africans who are married through civil rights. So customary marriages is not superior to civil marriages. It's just that it exists as a marriage. So in our law, customary marriage is up to you if you want to marry customary marriage. You marry customary marriage and it's recognized and you are legally married. And then there are proprietary consequences to that. Or you can choose to be married by civil rights. So it's not a question of competition between these two marriages. It's really a preference. And most African people, specifically the underprivileged, and with customary marriages. But the women in those relationships and in those circumstances are protected as much as a woman who is married by civil rights.
Please, thank you. The last one will be the Vice President. Sorry, with,
Merci.
maybe we can continue
Merci,
after
Madame la
with the
Présidente.
same.
Je vais aller
Oh,
rapidement.
Okay, will be the last one.
Okay.
Thank you very much. I'm going to go quickly. I'm Madam Lamine, Vice President. I'm going to go quickly because just now I thought that I heard President Lucia was talking about a day of a Mozambican woman, that is the 7th of April. I just want to understand that particularity because we know that at the level of internationally, the Women Day is on the 8th of March. Maybe there is a reason for them to have a different date that inspired them. Now, I also would like to address myself to Judge Bordia and at the same time the President Antonia. Just now, you spoke about the economical power of the woman. I believe that sometimes in certain families or in certain couples, the woman from the 1st to the 31st of the month, she lives depending on the man. Even her family sometimes depends on that man, regardless of the existence of legislation that are severe or the severity of the judge. In case there is a problem or issues that will bring her before the judge, she's not protected simply because she depends on that man. She depends on him economically, and we cannot also stop him from, being her boss because economically he's more powerful than her. Now, what can we do so that regardless of these legislations that protect her, and there's also the severity of the judge in case there is a case like that, but despite that, economically, because she does not have the means, she's supposed just to undergo and accept it. So what can we do so that the husband cannot just abuse her on a daily basis?
Thank you so much. Maybe before I pass the floor, I would like to answer the issue of the women. The 8th of March is the International Day of a Woman. We also celebrate in Mozambique, but we also have a day for Mozambican women, which is the 7th of April. This is to honor the women who participated in a struggle of independence. That's when Josina Machel, the first wife of Samora Machel, died. So she has been celebrated, and in the last 10 years, this data is commemorated with the women with a lot of energy and emotion. We celebrate not only those who participated in the liberating struggle, but the women today. I think Angola also, they have their own day of Angolan women. Therefore, these are national dates as compared to the International Women's Day.
And thank you, Vice President Tachi, for the question. In my presentation, I did indicate that economic abuse is not criminalized. But if you look at the Domestic Violence Act that we have in Zimbabwe, it sets out other avenues by which such a person or such a woman can be assisted. The matter can be referred for counseling. It can be there's a whole council which has been set up, which involves social welfare officers. It involves chiefs at the local level. So they would come in and help to resolve that matter at the family, at that level, and not in a criminal court. Thank you. I hope that answers your question.
Vamos agora passar à última intervenção.
We are going to the very, very last intervention.
President, Constitutional Court of Mozambique, for giving me this opportunity. I just wanted to add my voice. Sorry, my name is Jummai Sankey, Supreme Court of the Federal Republic of Nigeria. For me, it looks like there's a peculiar situation which we have in our country, which has not been accommodated in the discussion. Since Nigeria got its independence in 1960, we've had a number of constitutions: 1960, 63, 79, and now 99. In the 1999 constitution, we have recognized three kinds of courts. We have the High Court, which has appeals right to the Supreme Court. We have the Sharia Court of Appeal, which takes care of Islamic law matters. Then we have the Customary Courts of Appeal, which also takes care of customary court matters, which is traditional matters like marriage, inheritance, death, and so on. And so, marriages under these systems of government, systems of law, are all recognized. There's the Islamic law of marriage, there's the customary law of marriage, and there's the marriage under the Act. We got the marriage under the Act from the colonialists, the English, who passed it on to us. Now, most communities, most tribes, we have about 350 ethnic tribes in Nigeria. Before they enter into any of these marriages, a lot of them would go through the traditional marriage. That doesn't stop them from doing the Islamic marriage, the customary marriage, well, that's a customary marriage, and then the marriage under the Act, which is the civil marriage. Now, if there is to be a divorce, the law under the Sharia, the Sharia law governs the dissolution of that marriage, and it is followed strictly, and it is provided in the Quran and the Hadiths, and it is dissolved. And all the rights, property rights, inheritance rights are governed by that law. Has nothing to do with the civil law. Then the traditional law, for customary law marriages, we consider customary law as a matter to be proven by evidence. So if you prove that under customary law, you're entitled to half of the property of your husband, and the court pronounces that you have proven so, you will be given half. If you decide to marry under the Act, a lot of which goes through court or Sharia marriages also, you go to the marriage registry, you indicate your desire to get married. There's a caveat of 21 days for anybody who has an objection. Then you go to your court, to the church or the Islamic marriage. After that, if there's going to be a divorce, you go to court. And there, the Marriage Act governs all the issues concerning inheritance or alimony or custody of children and so on. So for us, we have three systems. And it's not one or the other. We have three systems. Yeah, you choose what you want. And the woman is covered that way. It depends on what you choose with your partner. Then when it comes to sexual assault and rape, we also have a few problems which we hope would be taken care of. They are taken care of in our criminal codes and not in our constitution. For us to prove rape, the person has to be either under 14 years of age or the person did not give consent. It's not 18. And then penetration has to be proven. Of course, it has to be a woman. That's all we have now. 14 years of age. But we seem to have an endemic proportion of sexual assault and rape in our country. And we're trying to address it by giving very stringent punishments. And like I think one of the speakers said from Zimbabwe, my experience when I was a prosecutor is that the men give very lenient sentences. And so what I used to do was I wouldn't present my evidence until I had a woman who was presiding. And I would get the justice for the little girl or for the woman who has been raped. But age of marriage, we don't have an age of marriage in the Constitution. We've been battling with that because of our ethnic backgrounds and our religious backgrounds. It's a very dicey subject. Thank you very much.
Okay. Well, thank you so much. Before I give back the word to the Justice Director Program, I want to say thank you so much for all the speakers to share with us your knowledge and experiences. Thank you too for the Assembly, for your participation, for your enthusiastic and the rich contribute. Please, Madam Justice Director Program, the word is yours.
Thank you very much, Chief Justice. This was a very informative session, and I see that people are interested, but due to time constraints, I think we need to take a break now. We'll have a lunch adjournment for 45 minutes, even under. I was hoping that we could come back at 3, but now it's already 25 past 2. So we'll have to be back by 10 past 3. Because we still have 2 sessions that we have to do. This may affect even the plans for later in the afternoon. So if we could kindly come back by 10 past 3, so that we can do the 2 sessions. Thank you. 3. which is going to be chaired by the Chief Justice of the Republic of Nigeria, Honorable Chief Justice Kekere Ekun. She's the Chief Justice of Nigeria and head of the Nigerian Judiciary, becoming the 23rd Chief Justice and the second woman to hold that office in 2024. She was called to the Nigerian bar in 1981 and holds an LLB degree from the University of Lagos and an LLM from the London School of Economics and Political Science. Her judicial career reflects a steady rise through the bench, from magistrate to the Court of Appeal, the Supreme Court of Nigeria, and ultimately the Office of the Chief Justice. She is also a life bencher, a member of the International Association of Women Judges, and currently serves as its president. Over to you, Madam Chief Justice.
Thank you. Good afternoon. I extend my warm greetings to the Chief Justice of the Republic of South Africa, Honorable Justice Mandisa Maya, other distinguished Chief Justices here present, honorable judges, esteemed delegates, ladies and gentlemen. It is indeed both an honor and a privilege to chair this important session on economic justice and women empowerment, convened under the enduring vision of the African Union and in celebration of 20 years of the Maputo Protocol, a landmark instrument that has reshaped the legal architecture of gender equality across our continent. The Maputo Protocol did not merely proclaim rights, it entrusted African judiciaries with a solemn responsibility to translate equality from aspiration into lived reality. Economic justice remains the foundation upon which all other rights stand. Without secure property ownership, inheritance, protection, financial inclusion, and equal secure property ownership, inheritance, and equal economic opportunity, access to justice becomes theoretical rather than transformative. Across Africa, we continue to confront complex intersections between statutory law, customary norms, and religious legal traditions. Some of those were highlighted in the earlier session. These systems form part of our rich legal heritage, yet they must evolve consistently with constitutional guarantees, human dignity, and the rule of law. Our courts have increasingly demonstrated that cultural identity and gender equality are not mutually exclusive. Rather, judicial interpretation has become the bridge through which tradition and constitutionalism coexist in harmony. Today's session, which is on landmark rulings on women's rights to property, inheritance, and financial inclusion, demonstrates that cultural identity. Today's session invites us to reflect on three critical pillars: the protection of women's property and inheritance rights, the careful harmonization of customary and religious legal systems, and the advancement of financial inclusion jurisprudence as a pathway to sustainable development. The judiciary occupies a unique position. We do not legislate policy, yet through principled adjudication, we shape societal transformation. Each judgment delivered with courage strengthens confidence in justice and affirms that equality under the law is not negotiable. As chair, I encourage frank, solution-oriented dialogue. Let us share jurisprudential experiences, confront persistent challenges, and identify practical pathways for consolidating the gains achieved under the Maputo Protocol over the last 2 decades. I look forward to an engaging and enriching discussion. Our first speaker this afternoon is Vice President Victoria Izata of the Constitutional Court of Angola. Ms. Victoria Izata, having been elected, is the Vice President of the Constitutional Court of Angola, having been elected unanimously by the National Assembly. She holds a law degree from the Faculty of Law of Agostinho Neto University and was already serving as Judge Counselor of the Constitutional Court at the time of her election. She has represented the court in important continental judicial forums, including the first meeting of African women judges in Libreville and the 4th International Legal Symposium of the Conference of Constitutional Jurisdictions of Africa in Addis Ababa. Her work reflects a sustained commitment to constitutional justice, judicial dialogue, and constitutional literacy in Angola and across the continent. I would plead with all our panelists to please keep within the time because we are trying to manage time effectively during this session. And it is my honor and privilege to welcome to the podium Ms. Victoria Izata. Thank you.
Angola, Angola, yeah. Veneranda Juíza Presidente Kudirat Kerek Ekun, muito obrigada. Honorável Veneranda Juíza Conselheira Presidente.
Honorable Mandisa Maya, on your name, I'll bring my warm regards of everybody present in this room. On behalf and in representation of Honorable Justice President of the Constitutional Court of Angola, Dr. Rawinda Brazil, I wish to greet all participants and all present and to thank the distinguished Chief Justice of the Constitutional Court of South Africa, Dr. Mandisa, for the kind invitation extended to our court to be part in this important event, for a warm welcome and good reception, working conditions, and conditions provided in this beautiful city of Johannesburg. Dear colleagues, taking a floor in this singular forum of big relevance, I do not only on behalf of the Constitutional Court of Angola, but also as a woman who, from one of the highest instant judicial of African state, witness with both legal and human sensibility the distance that sometimes that will between written in our normal daily life. The theme that gets us is jurisprudential protection of gender equality in Angola between customer practice of the effectivity of women's rights with the framework of 20th anniversary of Maputo Protocol is not only a mere academic reflection. It's, above all, the issue of constitutional justice. It's a matter of human dignity. And it's, above all, the issue that will be important to us directly as women in African judiciary that will be in the front line of interpretation of application of the law. In Angola and other African countries, there are more or less attention both systems which are norms which also regulate the human relation. On one hand, formal state law enriched by its constitution, ordinary legislation, and other, the customer law rooted in centuries of social practice, usage, and community values. This coexistence is, on its own, a source of richness. But when it's not adequately mediated by the rule of law, it can also become a source of inequality structure that which fall in a particular severity upon women. Allow me to share some data from our Angolan experience. Angolan estimate of a population estimated about about 37.9 million inhabitants. On those, 50.52 are women, which corresponds approximately 19.1 million. On this, between 69 and 70 are in urban areas and 31 in rural areas. It's important to note in our urban context, a portion significant of this woman, their place called Musek. It's an informal settlement, spiritual marked for increased social economic. Furthermore, 34.5% of households are headed by women, a figure that increased in the urban areas. The poverty rate is about 41%, being that women are the majority of that poor population. Excellency, in this context, that we contest our paradox of a woman, which is formal, which is a heritage with no excess of the same. The Angolan Constitution was approved in 2010, expressed the inequality arrangement between women and men. Established that no one is before the law, no one can also be privileged or based on sex. The equality between spouse and guarantee on the right of family and marriage in full equality. In norms, it's there, it's clear, it's binding, and it occupies the apex of our legal order. However, the social reality demonstrates that in various parts of Angola, many women continue to see their rights being exchanged in their letter when confronted by the force of discriminatory practice. This issue experienced in Angolan side with manifest in essential these dimensions. First, autonomy. Despite the legal protection against forced and child marriage, they are consistent where young and women remain subject to matrimonial arrangement decided by council elderly without regard of the evil. The data are telling us. The second dimension is patrimonial. The woman that, because of the husband loss or death, is a legal beneficiary of inheritance. It often is excluded from this state due to practical traditional practice to asset transfer to deceased family. According to data from Ministry of Social Development and Women and Family, more than 40% of Angolan men are divorced of land, so they're not sharing with our feminine counterparts. In case of a month, the law is safe and which can be men or women, so the entitlement of about 50% of good for the couple when marriage has been celebrated on not obstant these norms, this social practice that between the marriage formally, which are constituted with more authority, this union, they are not recognized judicially, then to prevalence within the family of the deceased with the destiny of the patrimony that will be in a position that will be the surviving. An economic plan, 22% of them, they got a bank account against 36 of women, and about 14% of the company in Angola, they led by women. The third dimension is violence and blood. When the widow tried to exercise the law, it's confronted not about the timing, but the physical presence of the goods, the subtraction of those goods in West scenario, the cursive way, when a conjugal way, on which the psychological on the same.
Violação simultânea do direito de propriedade, do direito à habitação e da dignidade da pessoa humana. Angola figura entre os países da África subsaariana com esta prática permanente prevalente.
With this practice that is prevalent, it is rural areas experience shows that widows face systematically unfavorable customary decisions. in urban areas. Even with the favorable court ruling, there are obstacles there for the recovery of goods. Not infrequently, accusation of witchcraft emerge as a mechanism for the social legitimation of the eviction. The consequences are also upon the children, loss of the education, health, and nutrition. Dear colleagues, the issue of illiteracy is also central. The female literacy in Angola is between 62 to 66, whilst the male is from 79 to 82. The woman who cannot read often cannot access a law that protects her. So more than 50% of these on law faculties are women, with growing feminization. Nevertheless, significant deficits in civil registration persists in the hinterland, limiting the full operational of legal personality for procedural purposes. However, it is important to emphasize that the phenomenon of dispossessing of widows not limited to contexts of law schooling or ignorance of legal rights. Indeed, even the circles where individuals possess a high level of academic training and full mastery of the legal norms applicable to property and inheritance, practice resulting in the undue seizure of the widow's assets persist. In these situations, the actions of the deceased relatives do not stem from ignorance of the law, but rather from the influence of deeply rooted culture and social patterns. This, due to the normative force within communities, ends up overriding positive law, leading to the illegitimate appropriation of the state to the detriment of the women who is by law legitimate heir. Such reality highlights the tension between formal law and social practices, demonstrating that a simple knowledge of the law is not sufficient to guarantee its effectiveness. The prevalence of the behavior contrary to the legal order reveals the need of a comprehensive approach, including not only the rigorous application of the law by the courts, but also the promotion of cultural and social shift. The protection of the widow, it must be taken with priority, requiring a concerted effort between the state, judicial institution, and society to ensure respect for property rights, human dignity, and the principle of gender equality, regardless of educational level of the woman. The Angolan Constitution recognizes in Article 7 customary law, but only within the limits of the Constitution itself. Here lies the core of debate. No customary practice can claim legal validity when it collides with the human dignity and without discrimination. The prevalence of fundamental rights over discriminatory custom is not an ideological choice. It is constitutional mandate. Excellency, it prevails. The norm is not the same as prevailing in life. It is precisely here that the role of women exercising leadership in the African judiciary becomes decisive. The Constitutional Court of Angola has been affirming a firm jurisprudence in rejecting custom as an instrument for eroding fundamental rights of the women. However, the courts cannot work on its own. The realization of these rights accumulates action from states, and it requires from us women the historic conscience and a compromising and transformation. Each judgment that affirms equality, each decision that limits the woman from what she is due to receive. So, allow me to conclude with commitments that I humbly propose. First, the commitment to an active constitutional interpretation that subjects customary practice to the fundamental rights. Two, the commitment to bring the courts closer to the communities through legal literacy, mobile, and mechanisms. Third, the commitment to achieve solidarity among women of the African courts through the sharing of jurisprudence experiences and institutional support. The data I present here are not abstract numbers. They are concrete lives. They are widows evicted from their homes. They are girls kept away from school. These are women prevented from exercising their rights that the Constitution recognizes. I bring from Luanda a conviction that is profound. Law that does not reach a woman in her concrete life is an incomplete law. And a judiciary that tolerates the incompetence that has not fully fulfilled its constitutional mission. To us, the women who lead the African judicial power belongs the honor and the duty not to settle for anything less. Thank you so much.
Thank you very much, Ms. Victoria, for that very good presentation. She started with statistics, which is always a very important place to start, so that we actually understand our perspectives and the magnitude of the problem. And some of the things that have been highlighted is the fact that the challenges affecting economic rights are not because of ignorance, it's because of cultural norms. And those are the areas that we have to look at in ensuring that we promote these rights. She mentioned tension between formal law and cultural practice, and this is reflected in so many areas, widowhood rights, and there are so many other things, ownership of property. She has also emphasized the fact that our role as women is extremely important and that our jurisprudence, our judgment writing, should reflect a firm rejection of the violation of these rights. She has also recommended active intervention that subjects customary law to fundamental rights. So whatever customary laws we have, they must reflect fundamental rights that are enshrined in our various constitutions. And she also made the point that a law is incomplete if it does not respect or recognize human rights. On that note, I want to introduce the next speaker, Honorable Justice Elizabeth Gwanza. She is the Deputy Chief Justice of Zimbabwe, one of the country's most senior jurists. She was appointed as a judge of the High Court in 1998, elevated to the Supreme Court in 2002, and became Deputy Chief Justice in 2018. Before joining the bench, she served in senior legal and public sector roles, including as Director of Legal Aid in the Ministry of Justice and as the first Director of Legal Affairs in the Ministry of Community Development and Women's Affairs. She is also a founding member and former president of Zimbabwe Association of Women Judges and a member of the International Association of Women Judges. It is my honor and privilege to welcome you to the floor. Thank you.
Good afternoon, all. On behalf of Zimbabwe, I wish to also extend our appreciation to the Honorable Chief Justice of South Africa, Justice Maya,
and the South African Judiciary for the very warm welcome that was extended to us, and for hosting this very, very important conference. It is indeed an honor for me to stand here as an invitee from our hosts to address the gathering on the issue of judicial approaches to advancing economic justice and women's empowerment. There's, of course, a lot that one can say, and a lot that is in my paper. I'll try not to address each and every one of them. The document will be available, I'm sure, to everyone who wishes to have a copy. In commencing discussion on judicial approaches to advancing economic justice and women's empowerment, one observes that there exists across jurisdictions a discernible gap between the promise of formal equality and the lived experiences, the lived economic experiences of women. And this is something that applies in many other spheres as well, the difference between theory of the law and practice of the law. While many constitutional and legal frameworks affirm gender equality, many women remain structurally excluded from full participation in economic life. For present purposes, gender equality is understood not merely as equal treatment regardless of gender, but as the equal recognition, protection, and participation of all persons within legal and institutional frameworks, including through measures aimed at addressing historical and structural disadvantage and advancing substantive equality. Economic justice, properly understood, and as, sorry, I'll read that again. Economic justice, properly understood, concerns the fair distribution of resources, opportunities, and economic benefits within society. Women's empowerment, in turn, speaks to the expansion of women's real capacity to participate fully and effectively in social, economic, and public life. These are not mutually exclusive ideas. Instead, they are mutually reinforcing imperatives, because without access to economic resources and opportunities, the promise of empowerment for women remains an illusion. As judicial officers, and in particular, as women within judiciaries, we are uniquely positioned to confront these gaps. Through principled interpretation, the development of jurisprudence, and the conscious application of the law, courts serve as critical instruments in shaping economic realities and advancing at substantive gender equality. It is necessary at the outset to break down some of the aspects that I will be looking at that make up the subject under discussion. And I'll start with women's empowerment. In essence, women's empowerment denotes the process of providing women with the necessary resources and opportunities to exercise their rights, participate in decision-making, and have control over their lives. Women's empowerment is a significant global issue with many organizations and governments recognizing the importance of gender equality in sustainable development. It therefore includes the ability to make independent economic decisions, equal access to productive resources and opportunities, and meaningful control over income, property, and other economic assets. It may be noted that an allied concept to economic empowerment is that of economic independence. This is central to empowerment because economic dependence constrains autonomy in both private and public life. Where women lack access to resources, which is the case in many, many situations, their ability to exercise constitutional rights, participate in economic activity, and influence decision-making is very limited. Women's empowerment is therefore inseparable from gender equality. Economic justice represents one of the primary routes through which equality becomes real, as it addresses structural barriers that prevent women from translating formal rights into lived experiences. It follows from the above that economic justice demands that there should be equal access to resources, fair distribution of economic benefits and responsibilities, and protection of rights relating to property, labor, and life laws. Therefore, it focuses on whether legal and institutional arrangements enable equitable participation in economic life. For a full understanding of economic justice, it is necessary to appreciate its relationship with gender equality. Economic exclusion is, in that sense, a gender equality concern because it entrenches structural inequality despite formal equality guarantees. Where women lack equal access to property, employment, or productive resources, patterns of dependency are reproduced, and participation in society is constrained. The absence of economic justice thus undermines substantive equality and greatly limits women's empowerment. In order to properly examine the relationship between economic justice, women's empowerment, substantive equality, and judicial role, it is necessary to consider the conceptual framework. And talking about the situation in Zimbabwe, the Constitution of Zimbabwe provides a useful foundation for discussing the connections between these concepts and the normative basis upon which they rest. For instance, Section 56 of our Constitution guarantees the fundamental right to equality and non-discrimination, while Section 80 affirms that women and men have equal rights and opportunities in political, economic, and other spheres. Section 26, on the other hand, requires equality of rights and obligations of spouses during marriage and at its dissolution, which directly affects control over family property and economic resources. These provisions operate together to form an integral framework for economic autonomy and empowerment. Regional and international instruments further reinforce this constitutional framework. And we are talking here of the Protocol of the African Charter on Human and People's Rights on the Rights of Women in Africa, and that is the Maputo Protocol. This protocol requires state parties under Article 2 to combat discrimination through legislative and institutional measures. Its Article 13 recognizes women's economic and social welfare rights, including equal pay for equal work, equal opportunities in employment, and protection from exploitation. And Article 19 links women's rights to sustainable development and access to productive resources, thereby situating economic empowerment within broader developmental goals. Similarly, international frameworks such as the Convention on the Elimination of All Forms of Discrimination Against Women, which obliges states to eliminate discrimination against women and to secure equality in political, social, economic, and cultural life. Further, the Sustainable Development Goals, which recognize gender equality and women's economic inclusion as essential to sustainable development. These instruments are significant not only as normative commitments binding upon or guiding states, but also as interpretive resources that may assist our courts in giving fuller content to constitutional guarantees of equality, dignity, and non-discrimination. In that regard, courts may draw on them to interpret rights purposively, to expose the structural character of women's economic exclusion, and to develop jurisprudence that responds to lived realities of those who are disadvantaged, and most of those are women, as we know. Through such an approach, judicial decision-making does more than restate abstract commitments to equality. It helps translate constitutional and international norms into concrete protection for women's economic agency and thereby advances substantive equality. I will address now the role of the judiciary, and that is the role for all of us here in advancing economic justice and women's empowerment. And in constitutional democracies, the judiciary plays a central role in advancing economic justice and women's empowerment. This is because courts deliver economic justice directly through the interpretation and enforcement of constitutional rights, including equality, property, and labor protections. By invalidating discriminatory rules and practices, courts can improve barriers that impede women's access to economic opportunities. And as women, hopefully we can try in the course of our work to interpret various laws that affect women. We try to do that while applying what they refer to as the gender lenses. The judiciary also influences economic justice indirectly through the resolution of disputes in areas such as family law, labor relations, and commercial decisions. Decisions in these matters shape economic outcomes, affect control over resources, and establish precedents that influence institutional behavior. The relationship between economic justice and women's empowerment is most clearly revealed in the everyday work of our courts. Control over property and inheritance remains one of the clearest indicators of economic agency. At its core, the inquiry is whether women are recognized as autonomous economic actors capable of owning, transmitting, and benefiting from property on equal terms with men. Legal systems that deny women inheritance rights or security of tenure, particularly under customary law, perpetuate dependency and entrench gender equality. Conversely, economic justice is advanced where courts interpret and apply the law in a manner that affirms women's equal entitlement to property. The judiciary, therefore, bears a critical interpretive responsibility in harmonizing various laws, including customary law, with constitutional principles, ensuring that cultural practices are developed and applied in a manner consistent with fundamental rights. properly understood, the protection of women's inheritance and property rights transcends private law concerns and assumes the character of a constitutional imperative, one that directly enhances women's economic independence, dignity, and long-term security. A second and equally significant site of economic justice lies within the family, particularly in the distribution of matrimonial property upon divorce. This raises the fundamental question of how the law recognizes and values women's contribution within marriage. Historically, legal frameworks privileged direct financial contributions, often to the detriment of women whose labor is predominantly unpaid and domestic. A constitutionally aligned approach, however, recognizes that caregiving, household management, and other non-financial contributions are integral to the accumulation of wealth within the family. In Zimbabwe, for example, this principle is reflected in Section 7 of the Matrimonial Causes Act, which empowers courts to make equitable distribution orders upon divorce. And we are talking of distribution of property acquired in the course of the marriage. Judicial interpretation has increasingly evolved to recognize both direct and indirect contributions, thereby transforming what has traditionally been regarded as invisible labor into legally recognized economic value. I notice that my time is up. Let me skip more paragraphs and come to the conclusion, Madam Chair. Just to mention that the paper goes on to cite quite a number of cases that have dealt with these various issues that I'm talking about, including issues to do with inheritance rights of women, and the sharing of property on divorce, depending on the different circumstances, cases where cases which led to law reform, for instance, in the case of distribution of property on divorce. Under customary law in Zimbabwe, on divorce, the woman was not entitled to any of the property that she would have assisted or contributed in acquiring. The law was changed to a situation where, regardless of whether it's customary law marriage or civil marriage, upon divorce or parting, parties share the property that they owned. And similar amendments were effected to the law of inheritance, where there were customary law marriages and where there were civil marriages to align them with each other. And so a lot has been done in that sphere. And the way that the courts interpreted various laws helped a lot in influencing these positive changes. Thank you very much. I'll end there.
Can we give another round of applause for Honorable Justice Gwanza? And because her paper was quite detailed and very explanatory, I think I will save us time by not summarizing it, but just to say that she has emphasized that our role is to deliver economic justice through the validation of guaranteed rights in our decisions. Our decisions set precedents, and we also have the assistance of regional and international instruments that can enhance our interpretation of our various constitutions. I think I will leave it there so that we have some time for discussion. But thank you very much for that very illuminating paper and letting us know some of the things that are being done in Zimbabwe to ensure the protection of economic rights for women. Our next and final, though not the least, panelist is Mr. Joseph Owandalt Bere. Apologies for any mispronunciation. It's always good to have the perspective of the other gender when we have these conversations. And I think it's also a good thing for you also to see that we invite those perspectives. So we're not just talking within ourselves, because this whole meeting is about exchange of ideas. And just as we say women bring a unique perspective, the gentlemen also have a perspective. So, Mr. Joseph Owandalt Bere is a Gabonese engineer and public figure who previously served as Vice President of Gabon during the transition period from September 2023 to May 2025. He trained as an electrical engineer at the Institut National des Sciences Appliquées in Lyon and built a long professional career in the energy and petroleum sectors, including work with the Société d'énergie et d'eau du Gabon and the Société d'entreposage des produits pétroliers. He brings to public service substantial experience in infrastructure, governance, and national administration. And definitely this is very critical when we are talking about women's economic rights. So it is my honor and pleasure to welcome you to the podium. Thank you. And I think I will need a microphone for the interactive session. Thank you.
Ladies and gentlemen, President and judges of our African Court, dear colleague, ladies and gentlemen, representative of specialized agency of United Nations, distinguished guests, as jurist, I will call for your so. It is an honor today as a Dean of the Constitutional Court of Gabon, representing the President Dieudonné Obaono, who is unable to attend, to take a floor to commend the Bureau of African Constitutional Jurisdiction for having once again taken initiative of this second meeting after the one in Libreville, organized jointly with the Constitutional Jurisdiction of the sister Republic of South Africa. It is an opportunity for me. To really this with Maputo Constitution for the next generation. To give to women judges the essential tools to play a key role in promoting transformative jurisprudence of gender equality in Africa. Yes, ladies and gentlemen, raising such a topic is tantamount to highlighting the influence of the principle enshrined in the Maputo Protocol and national legislation. Ladies and gentlemen, it is in this spirit that our reflection will focus on economic justice and empowerment, drawing his historical decision relating to women's rights and matter of property, heritage, and financial inclusion. Indeed, the history of Gabon women to access property is marked by the slow emancipation from male guardianship, moving from the status of a legal minor to that of autonomy. This and Gabon, our country, has taken historic step in having a constitute on the one of the hands solemn affirm in the Constitution, in particular of Article 20 of the same text, that every Gabonese citizen has the right to a right of property. In addition to this legal arsenal, this is, among other things, Law number 006 to 2021 of September 6, 2021 on the elimination of violence against women, with enshrine strict equality between gender access to property and family status, and Ordinance 006 of 2026 in February 2026, establishing the land ownership regime in the Gabonese Republic. This sufficiently demonstrates not only the effort made by the Gabonese government to protect women, but also attest that under Gabonese positive law, women, in addition to having a right to property and use can also acquire a title deed. The government has also implemented a social housing program, notably through the National Real Estate Company, to facilitate access to home ownership for a civil servant. Finally, in this year 2026, reforms are underway to clean up the management of the social housing and combat illegal occupation, with can influence access to housing. However, while Gabon has made progress in guaranteeing equal land right, marked by the significant legal development toward gender equality, women's actual access to property remain a complex issue. Cultural barriers and entrenched customacy. Ladies and gentlemen, regarding a woman heritage right, important to remember first and foremost, that is a traditional Gabonese law. Women were excluded from this. Moreover, the widow and her children were considerably interred part of the discerning estate, which the rightful belong to the family and whatever. However, women acquire new right. The widow will change the family status to acquire. Today, Gabonese legislation no longer make gender distinction in inheritance. Girls have the same right as a boy to inherit from their parent. Indeed, the reform of a civil code, which took place on June 15, 2020, abolished the discrimination, thus allowing women to be heir of a family, to manage their own property, and to have the same inheritance right as a man. Article 683 of the same civil code also established the surviving spouse, including in a widow, has a legal heir alongside the children and ascendant. As in the case, she enshrined a life interest in one of the quarter of the estate. Since civil marriage is the only recognized form of marriage that protects the widow, she has a right to habitation and use the principal residence and its furnish. It is the case of a marriage under the community of property regime. to surviving a spouse in the co-own of the access acquired during the marriage of a receive and has an heritage. As the form of marriage of heritage, it is handled by the succession civil, which has replaced the community of property of the family council, because many women really renounce sometimes to the right and based on the reprisal from the family. Furthermore, the assistance provided by a republic authority often prove ineffective because the slowness, laxity, and bad faith of the ending in case of handing the success of heritage. Ladies and gentlemen, regarding the last point concerning the financial inclusion of women in Gabon, this is progressing but remain limited despite organizing initiative to strengthen access to and on the financial service. Indeed, a study entitled African Women, including Index 2025, published by the African Center of Economic Transformation, revealed that Gabon ranks 17 out of 42 African countries for women financial inclusion. And overall performance that is up like the African country. However, despite of this progress, Gabonese women, particularly those from the rural area, who are the key driver of equitable and sustainable development in our country, still face obstacle in accessing financing. This is especially true since bank primarily access a repayment capacity and bank account management indicator that can limit the guarantee of a credit to women entrepreneurs. Furthermore, in the essential that women use the service strategically by overcoming a social barrier and development and financial literacy. Therefore, to develop a women financial inclusion, the Gabonese government has implemented several initiatives. The project supporting rural entrepreneurship, such as empowering youth and women-led SMEs, program founded by the IDBCs, Fund and UNDP, aim to mobilize the cassava sector and introduce innovation technology. Advocacy for the creation of one-stop shop and a training space dedicated to financial inclusion in order to facilitate access to use of financial service. The implementation of a national strategy to 2024-2033 aim to gender equality. In conclusion, it is clear for all the above that equality over years has become a major issue for development of women's rights, but also for the technical and economic process of Gabon. This issue must be said. It is a great importance because we must bear in mind that the principle of equality underpin all the rights and conditions. The authority of our country were not mistaken when they committed themselves to a proactive policy for equal rights between sex and emancipation women. It is not surprising at all to see them today at the control of the aircraft and electricity pole, authorize the work and voltage and limited ourselves. This already a major in the judiciary they are visible, strengthening their presence in the medical and paramedic field, still a majority in the defense and security forces. And they continue to distinguish themselves in their heritage across the balance of the armed force. I would like to thank you.
Delivered paper and within the time. Thank you very much. We have been given the perspective of Gabon, and the speaker has told us how the country has taken historical steps in terms of amending the constitution to remove any discrimination on ownership of property on basis of gender. The country also now has a national housing policy that recognizes the rights of women to own property. Also, reforms have been put in place to combat illegal occupation of housing. Another area, no gender distinction in inheritance laws anymore. Women are now recognized as heads of family and have inheritance rights. In spite of all these very proactive and enviable developments, as we have heard from other presenters, women still face challenges, especially in rural areas. Again, he has mentioned that there are some other initiatives like women and youth-led SMEs, advocacy for one-stop shop, and that the principle of equality is paramount. I think what is important is that from Libreville till now, we can see that there have been very positive developments across all the jurisdictions who have given us presentations this afternoon. And I'd like us to thank them once again for their excellent presentations. Thank you. Thank you very much. We have a very, very short period for interaction. So I may take just maybe 2 or 3 contributions because we still have one more session to go. Yes, please.
Okay. Merci, Madame la Présidente.
Thank you very much, Madam Chair. I'm Madam Fatimata, constitutional judge in Burkina Faso. I just want to recommend all the panelists for the content of the exposition. I would like to ask a question to the last interv who finished his communication, who really a quote. They say women will be emancipated if they do have the same right to education. And I believe that in so many countries, the civil society as well as the government are doing a lot to register women at school. And I believe that in Burkina Faso, we have reached the rate of 50-50. But the reality is the sustainability of those ladies at school. The problem is not to register them at school, but to maintain them at school. So I would like to we realize that there are some school in Burkina Faso where in the same class there are 21 ladies, girls who fell pregnant. And now you see there everything will stop right there, and the organization or the government has really now come on the street. Sometimes it is something that is more neglected in the society, and as a women we need to invest ourselves more to be a role model, and we need to bring a a penalty, to discourage those who are really impregnating those young women. So I would like to have your view on that question. I thank you very much.
Thank you.
Je vous remercie de cette question. I really thank you for the question. If I can already enlighten your, it was because it's been a while in the primary school. A teacher who were found guilty of that activity will face imprisonment. But if today, if a young lady fell pregnant, after she deliver her baby, she can go back to school without any discrimination. You are right to underscore at that point. We need to really move severely on that case. That is the only thing I can add or give you as an answer. Thank you.
Thank you very much. I think that question was more of an observation and perhaps something that all of us should just, take on board, that there are these situations where we are talking about economic justice. It means we need educated women. And in the process of being educated, it's being truncated because they fall pregnant. Mm-hmm. So it's something that we all have to think, what is the impact of that? And does it necessarily mean that as long as you are pregnant, you cannot continue your education? If you are not ill, you should be able to continue your education, unless it's actually physically affecting your presence in school. Thank you very much for that contribution. Another comment, contribution? Oh, yes, please.
مرحبا جميعا.
Good evening. My name is Fatima from the Sahrawi Democratic Republic. I have a simple question. I hope that I would find an answer for, and it is in the general context. How can we realize the economic justice for women in the areas of conflict? The women in the Sahrawi Republic are an example of that. Thank you very much.
The panelists want to respond to that question. Women in areas of conflict. Do you have any suggestions? Or is it just something for us to think about? Because when we are talking about, the protection of women, it also boils down to our interpretation of the various protocols. So I think it is something just to draw our attention to the fact that these protocols will be very useful in deciding cases where women are experiencing violence or other impediments because of being in a war situation. All these international instruments, and particularly the Maputo Protocol, should be helpful to us in those areas. Does anybody have any other contribution on that? All right, thank you. I think there's one more hand there. Thank you.
Thank you. My name is Judge Judy Zulu from Constitutional Court of Zambia. I just wanted to share a recent case which happened in Zambia, highlighting in relation to the role of the judiciary as presented by the Deputy Chief Justice of Zimbabwe. Recently in Zambia, there was a domestic worker who was convicted and sentenced to 7 years for illegal abortion because she used the harmful herbs. When the matter came up on appeal in the High Court acquitted her, recognizing that her economic status, she was unable to afford the cost to do illegal abortion under the Termination of Pregnancy Act. So the court recognized that her economic circumstances should have been recognized as a legal defense. So she was acquitted on that basis. Thank you.
Thank you very much. I think that example is one of the benefits of this sort of engagement. We are talking about economic justice, and what was taken into account is that if this person had the economic ability to access the proper method, then it wouldn't even have been an offense. And therefore, the courts used that consideration of economic lack of economic empowerment to, I guess, temper justice with mercy. So thank you for that contribution. I'll take one last question or contribution. All right. All right. With that, I think I can bring this session to a close. I want to thank all our panelists. I also thank you, participants, for your rapt attention. And I think a request has been made that the papers that have been presented should be made available to us. Many of us would like to go home with them and study them in more detail. With that, I hand over to the Director of Programs. Thank you for the next segment. Thank you very much.
It's fine. Thank you, Chairperson. This was a very informative session. Thank you very much for handling it for us. And I noted that you were able to also capture some of the recommendations that will be useful for purposes of compiling the resolutions. Thank you very much for that. We will take a 10-minute movement break to allow the panelists for the next session to move up to the stage. Thank you. to come on board. At some stage, we had a delegation from Brazil, but they couldn't make it. So we are quite grateful for your intervention and coming up to assist us. Thank you very much. I'll just introduce the chairperson of the session, Justice Nasne Salawada. She's the president of the Court of Appeal of the Gambia, a position she has held since 2022 as the first Gambian woman to do so. She holds an LLB honors degree from Anglia Polytechnic University, a BL from the Sierra Leone Law School, and an LLM in Human Rights from London Metropolitan University. Her career has included service as a High Court judge, a Justice of the Court of Appeal, Acting Solicitor General and Legal Secretary, Deputy Director of Public Prosecutions, and Senior Counsel within the Attorney General's chambers. Justice Salawada has also contributed to continental legal development as a member of the African Union Commission on International Law and through her work in regional human rights institutions. I hand over to you, my sister. Thank you.
Thank you, my lady, for that introduction. Good afternoon, Honorable Chief Justice of the Republic of South Africa. I'm not sure whether she's still in the room. Honorable Chief Justice of the Republic of Nigeria. I beg to stand on all the other existing protocols. And in this session, the discussions will focus on the relationship between environmental protection, women's rights, and the role of the judiciaries in Africa. At the center of these discussions is the Maputo Protocol, particularly in its Article 18, which recognizes that women have the right to live in a healthy and sustainable environment. This, in my considered view, is particularly important because environmental harm is not gender neutral. You will agree with me, colleagues, that across Africa, women are often the most affected by pollution, climate change, land degradation, and general lack of access to natural resources. Therefore, there is a general consensus that protecting the environment is also about protecting women's dignity, women's health, and equality. My understanding of Article 18 of the Maputo Protocol requires states to do the following three things. Firstly, to ensure that women have the right to live in a healthy and sustainable environment. Secondly, to promote women's participation in environmental decision-making. And thirdly, to ensure that development policies take into account the needs of women. This provision in the Maputo Protocol is very powerful because it goes beyond protection. The article demands for participation and representation. Women must not only be beneficiaries of environmental protection, but we must also, as women, be active decision makers. At this point, I wish briefly to pause and to reflect on why participation and representation matter in the protection of the environmental rights of women. Participation means that women must be involved in decisions about land, water, climate change, etc. Representation means that women must be present in institutions such as government bodies and environmental agencies, the courts, and legal systems. Without participation and representation, therefore, environmental decision risk and reinforcing inequality. For example, when mining or oil projects are approved without consulting communities, it is often women who suffer the most, from loss of livelihood to health risks. The role of the judiciary. The judiciary plays a critical role in making these rights very real. The courts are responsible for interpreting laws and treaties like the Maputo Protocol and domestic legislations on environmental protection, holding governments accountable for violations and providing remedies when rights have been violated. Therefore, and importantly too, courts can link environmental harm to human rights violations, including the rights of women. I am sure that my sisters, the Honorable Justice Nambita Dambuza and Justice, beg your pardon, Justice, I'm struggling to find the name, Justice Lamini, whom I shall be inviting in a few moments to talk to us about sustainable development, participation and representation, will have a lot to share with us, given how the courts in South Africa and across Africa have contributed to environmental protection and ultimately to the protection of women, as I know that many cases on environmental protection have been litigated and determined before the courts in South Africa and the rest of many countries in Africa, for that matter. Similarly, the African Court on Human and People's Rights have recognized that environmental harm, such as toxic waste, can violate the rights to a healthy environment and other human rights. Similarly, courts in countries like Namibia, Lesotho, Kenya, Nairobi, and Malawi, to name a few countries, have dealt with cases involving land use, oil exploration, oil pollution, environmental decision-making, and resource governance, showing a growing body of environmental jurisprudence in Africa. What I have gathered from most of the jurisprudence that I have looked at on these cases on environmental protection is that the courts have enforced environmental rights. The courts promote participation, and the courts advance gender justice indirectly by protecting vulnerable communities who, more often than not, are the most affected groups. In conclusion, I am of the view that many of the judiciaries in Africa are playing very pivotal roles in ensuring that women live in a healthy and sustainable environment through progressive interpretation of the laws, enforcement of environmental rights, and the promotion and participation of courts across the African continent are helping to give meaning to Article 18 of the Maputo Protocol. But there still remains several challenges, such as lack of access to the courts, the expense associated with instituting legal proceedings in the courts, especially by women, lack of awareness by women of their rights under the Maputo Protocol. And the most significant challenge, in my view, is the lack of effective implementation of the decisions of the courts. With this brief opening statement, I have the pleasure of inviting Honorable Justice Nambita Dambuza of the South African Constitutional Court from next week to make her presentation on this very important subject. But before I invite her to come in, Justice Nambita Dambuza is currently a judge of the Supreme Court of Appeal of South Africa. And next week, she'll be a judge of the Constitutional Court of South Africa. Which is located in Bloemfontein in the Free State province. She has served as a judge of that court for 10 years. Prior to that, she was a judge of the High Court in the Eastern Cape province for 11 years. She has also served as a judge of the Competition Appeal Court and an acting judge of the Constitutional Court of South Africa. Her other positions include chairperson of the Rules Board for the Courts of Law in South Africa, visiting professor at the Rhodes University Faculty of Law in Mahanda, South Africa, chairperson of the Nelson Mandela University Council, South Africa, judicial educator with the South African Judiciary, board member of the Global Judicial Institute on the Environment, board member of the South African Legal Institute, and trustee of the Heatherbank Farm School in Habana, South Africa. I guess I'm pronouncing it right, I only hope. Previous positions include member of the Judicial Conduct Committee of the Judicial Service Commission, South Africa Council member of the South African Judicial Education Institute, SAJA, convener of the New Judges Orientation Seminar, South African Judiciary, chairperson of the African Judicial Education Network on Environmental Law, and chairperson of the Walter Sisulu University Council, South Africa. My lady, you're most welcome to take the floor.
Thank you very much, Justice Salawada, for that introduction. And let me greet everybody this afternoon. To all the Chief Justices that are in the room today, to the honored guests, my colleagues, all of you, ladies and gentlemen, I stand on the protocol that my Chief Justice so thoroughly set out earlier in the day. Good afternoon. Firstly, let me thank Justice Lamini for agreeing to be with me on this panel, because all along, nobody wanted to be with me. Throughout the week, they kept asking for people to be on this panel, and everybody was saying, no, I don't know what Justice Lamini doesn't know that other people know who don't want to be with me. But I'm grateful that I'm not alone on this panel. I thought for this topic, I should start by just setting out what Article 18 of the Maputo Protocol provides. But essentially, it is the wording is the word language that we are used to, that we've seen in so many of the instruments that regulate environmental law. It guarantees women the right to live in a healthy and a sustainable environment, firstly. Secondly, it imposes obligations on the state parties to ensure greater participation of women in planning, in management, and preservation of the environment, and in promotion of research and investment in new and renewable energy sources and appropriate technologies. All of this aimed at improving, particularly on this clause, the lives of the women of the continent of Africa. Sustainable development in this continent, therefore, in line with this article, consists of a framework of other initiatives of the African Union. It consists of, it is sort of a three-tier system that is constituted by a continental framework. There's the next slide, please. There's a number of protocols that have been set by the African Union. All of those, I'm not going to read all of them. This is part of the continental framework that governs our environmental law space and the protection of the peoples of the continent of Africa. In the second tier, there are regional community laws. And these are laws that emanate from regional authorities such as ECOWAS, the East African Community, and the SADC. And then at the bottom, we have the national constitutions of countries and the laws that are enacted in terms of those laws, of those constitutions. What we see, though, or what I observe, is that contrary to the explicit expression in protecting women's rights that we see in the Maputo Protocol, that Article 18, our laws generally, including our constitutions, are framed in general terms. For example, we know that the countries such as South Africa, Kenya, Nigeria have clauses in their constitutions that protect environmental rights. In Kenya, it is in Articles 42 and 69 of the 2010 Constitution. And those articles guarantee the right to a healthy environment, and also, again, in line with the protocol, impose obligations on the state to protect natural resources and enable citizens to enforce these rights through the courts. In Nigeria, Section 20 of the 1999 Constitution provides that the state shall protect and improve the environment, safeguard water, air, land, forest, and wildlife. Zambia also has an act, and so do other individual states. In this country, Section 24 of the South African Constitution guarantees to everybody the right to an environment that is not harmful to their health and well-being, and ensures that the environment shall be protected by the state for the benefit of present and future generations through reasonable legislative and other measures. And then we have all those and other legislation. We have quite a comprehensive set of legislation that is intended to protect the environment, people from environmental harms. But as you know, we have not done much to incorporate the features of gender justice into our jurisprudence, despite the protocol having been in place for this long. And despite our awareness of the extent to which vulnerable people in our communities get affected by environmental harms, as the program director has mentioned. So I have tried in this paper to look at the jurisprudence that we have to see whether the principles that we have established in resolving disputes that serve before us can be enhanced to explicitly protect women and children and other vulnerable people in our societies. And I shall do so by looking at 4 cases that emanate from this country, and I've got one from Nigeria. The first of these cases is the Fuel Retailers Association of South Africa, which is one of our first cases that sort of sets out the approach that we employ in determining the interaction between economic development and the protection of environmental rights. In this case, the Constitutional Court set out the approach as follows: that economic and social development is essential to the well-being of all human beings. And socio-economic rights that are set out in the Constitution are indeed vital to the enjoyment of other rights guaranteed in the Constitution. But development cannot subsist upon a deteriorating environmental base. And unlimited development is detrimental to the environment. And the destruction of the environment is detrimental to development. In other words, one cannot exist without the other. So essentially, the principle is that promotion of development requires the protection of the environment. That principle runs through most of the cases or judgments in which courts, not only in this country, throughout the continent, interprets the relationship between economic development and the right to a healthy environment. In Gembre versus Shell and Center for Oil Pollution Watch, this is the Nigerian judgment that I referred to. This was one of the first Nigerian judicial decisions where the court adopted constitutional human rights approach to environmental protection. So the Federal High Court in Nigeria held that the massive gas flaring by Shell and its partners violated the fundamental rights to life and human dignity, including the right to a healthy environment as enshrined in the Nigerian Constitution and the African Charter. That the people of Nigeria needed the development did not entitle Shell to do as it pleased and put the people of Nigeria in harm's way. And then the third of the cases that I chose is a judgment of the Supreme Court of Appeal, Gongose and others. This is a case that affirms that rural communities have a customary right to fish in protected areas. So in this case, fishing in protected areas became prohibited by the Marine Living Resources Act. But people of the community along the sea, the ocean, continued to fish as they had for the previous, they say, 300 years. And so the court was confronted with the issue of whether those rights the fishing rights that the community was asserting could be protected over and surpass the act that had been passed to protect the area concerned and conserve it for future generations. So we see these competing rights now at play. The first court, the Court of Quo, had found that protecting the right to culture, that is the fishing right, over Section 24, over the Section 24 right, was unsustainable. In other words, the practices of the community had to give way. But the appeal court, which is us, affirmed the right to cultural customary practices, because that right too, to protect customary practices, is a right that is protected in our Bill of Rights. This judgment, therefore, highlights the dangers of conceiving sustainable development, which the legislature was trying to do, in this case, in a purely Eurocentric way that does not take into account the ways of living of the people concerned. And the danger is that if we do that, adopt that approach, those measures taken to conserve the environment may not be sustainable, because the people will continue to do what they have been doing. So a more sustainable approach for lawmakers in confronting the conflict and settle on an agreed regulatory regime is required. The fourth and the last judgment is the trustees for the time being of Groundwork Trust and another. This is the judgment of the Supreme Court of Appeal again that was penned by Justice Mulimela sitting over there, and I was sitting with her. And this is the one of, if not the first, judgments in which the position occupied by vulnerable women is expressed. It is a case that concerns the ambient air pollution in the Highveld priority area in a province just close to here called Mpumalanga. It is the most polluted area in air quality in this country. And so in 2012, a plan was put in place to regulate the emissions within that region. But what was required was regulations so that the plan could be implemented. But the government then delayed implementing the regulations until they were taken to court. It is a case that made history because it was driven by women. It is the women from the Highveld communities that tendered evidence in their affidavits, because one would see that my child has asthma, and the second one, and when they talk to the neighbors, they express the same thing. So the women got together and they got assistance in driving this case. The court then accepted the evidence that low-income groups, such as women, children, and people with disabilities, are most disproportionately affected by air pollution. And it found that the minister had unreasonably delayed in preparing the regulations to give effect to the plan. So, essentially, again, this case illustrates the tension between economic development and the rights of the most vulnerable of people. And the SCA said, economic development cannot occur without environmental protection, going back to those principles that were set out in fuel retailers. And it also stated that the economic development at the expense of the environment and human life and well-being will automatically violate Section 24 and can never be justifiable. Those are the four cases then that I wanted to just highlight, and wondered how then these principles of sustainable development that emanate from these cases can be used to expressly protect the most vulnerable in our society. And there are other areas of conflict of practices, for example, hunting laws, laws that prohibit access to sacred areas, land use that had been, that is established, for example, for medicinal purposes. This is just general, men and women, all members of society. So these are the conflicts that will serve before our courts. And what I thought in going back to these principles, we could do is to be mindful of expressing, saying expressly, or highlighting how the impugned practices affect women and children and people with disabilities in our communities. I wondered whether it would be going too far to call for evidence of, for example, in consultative meetings, to pay attention as to who the people that were there, how were those meetings constituted, how many, if there were any women disabled, in order to know how your judgment needs to take into account the composition of the communities that we serve. I know that we are already criticized as judges, as anti-development, when we stop or delay infrastructure, mining, and other projects. And we are accused of procedural rigidity. And I think maybe that's what the minister, is it the minister or the speaker was referring to earlier in the morning when she said, Kanti, this consultation, where does it start and where does it end? What is sufficient consultation? Sufficient consultation, I think, has to take into account the circumstances of the community impacted. Otherwise, there is no point in the consultation. We are accused of not taking into account the energy needs of the country. Of course, we do acknowledge that our countries, I think all of the countries in our continent are in dire need of energy. But the principles have been laid as to how development, energy needs should interface with the right to a healthy environment. I think the key principles that emanate, that we can draw from the cases that we've been dealing with, that we can transpose to those cases where we find that women and other vulnerable groups are more impacted, are the following: that socio-economic and human rights and development needs of people cannot be separated from the environmental protection. And also to acknowledge that we are increasingly required to interpret what is justifiable economic development in a particular set of circumstances. And also that we could incorporate into our judgments that inclusive planning is key. We are not the lawmakers, but what we say in our judgments often finds itself a way to what becomes law in the end. So incorporating these cultural governance principles could be a game changer. So what we are trying to foment is that gendered environmental justice, or justice that recognizes the disabilities of members of the community, must be at the forefront of our minds as we decide these cases. Gender justice advocates for inclusive action and acknowledges that environmental injustices are not gender neutral. Again, as has already been said, women are most impacted on the average. They are the first port of call when food has to be laid on the table, when fires have to be made, when energy has to be produced, and this makes women direct victims of any scarcity because they are stakeholders in their families. And as such, they are also stewards of the environment because they appreciate the importance of the environment in their lives. So in conclusion, I think we as judges have capacity to shape the conduct of the communities and the societies we serve. Of course, our jurisprudence must be founded on existing law, but it is also important that existing law includes customary law, customary practices that we find in the communities. Also, we must keep in mind that we are not experts in everything. We must find scientists to assist us when science is involved, and sociologists also to assist us when ways of life is involved. So we must pay fidelity to separation of powers. We must know our boundaries. For our courts to be effective and relevant to the acute vulnerabilities of our continent, we must be aware of all these intricacies so that we can think expansively and be mindful that there is the continental framework from which we can draw in understanding how the lawmakers continentally perceive our problems. We can get a lot of material that helps us understand how our difficulties, environmental difficulties, can be approached. I think that is all for today. Thank you very much.
Thank you, my lady, for that very insightful, very informative, and very educative presentation. I'll ask us to give my lady one more round of applause for that presentation. My lady has been able to dissect Article 18 of the Maputo Protocol for us, as well as the continental legal frameworks of sustainable development in Africa. She has also unpacked the regional laws, such as that of SADC, as well as the constitutional and domestic legislations on environmental management and protection. Her ladyship has also given us a talk through on the jurisprudence and given us landmark cases in both South Africa and in Nigeria. Decisions from the South African Supreme Court of Appeal, landmark decisions they indeed were, and has also enlightened us on how the courts have resolved those issues of environmental matters before them. With that, I will now like to introduce Honorable Justice M.M. Lamini. Judge Momsi Lamini is an LLB holder. She started in the private sector at pupillage. She sat for a bar examination and was admitted as a lawyer. She joined the Director of Public Prosecutions as a Crown Prosecutor. She passed through as Crown Counsel. She later became the Senior Magistrate before her appointment to the Head of Prosecutions in the Kingdom of Eswatini, formerly Swaziland. She joined the bench in 2012 as a judge of the High Court. Judge Lamini has had several appointments as an acting judge of the Supreme Court. She also serves as a judge of the South African Development and Community Administrative Tribunal, SADC. My lady, you're most welcome to the podium.
I hope technology does not fail me. Let me embark straight to my presentation, which is not going to be long, rest assured. All protocol observed. As the topic has been well articulated, sustainable environment, participation, representation, the judiciary's role in ensuring that women live in a healthy environment. May I start by pointing out, okay, I must press this. Yes. So there you are. It is based on Articles 18 and 19, and these address the right of women relating to sustainable environment, participation, and representation. Briefly, Article 18 reads partly, women, and I quote, women shall have the right to live in a healthy, sustainable environment. Then Article 19b, women, and I quote again, women shall have the right to fully enjoy their right to sustainable development. In this connection, the state parties shall take all appropriate measures to introduce the gender perspective in national development planning procedures, ensure participation of women at all levels in the conceptualization, yes, decision-making, implementation and evaluation of development policies and programs. As already mentioned, the topic under discussion is the judiciary's role in ensuring that women live in a healthy environment. And I shall just zero my address to that perspective. True and fair, the protocol calls upon state or member parties to engage in affirmative and concrete actions in ensuring the right of women to live in a healthy and sustainable environment, and that they participate in decision-making or plan of action. We often think of the executive when it comes to such matters, that it is their role. The fact of the matter is, however, distinguished justices, that we, as the members of the bench, form one of the critical arms of government, or the state, as it were. We are the judiciary. Our Chief Justice, Begima Palala, addressing members of the judiciary, once stated, and I quote, judges are the servants of the people. The question is, what did the drafters of Article 18 have in mind when they promulgated that women have a right to live in a healthy and sustainable environment? Generally, the right provided referred to a safe, clean, conducive, and viable environment that will serve the present and future generation. Of paramount, judges speak through their pens, their judgments. Now I have this example. If we are faced with a case of this nature, lack of water, for instance, will more negatively impact on women than men. As Justice Dambuza has correctly pointed out, it is the women that must cook, clean, wash, and bath the children. So if a giant company, for instance, uses the river as a dump site, where litigation takes place, the judge, in its function to use the pen to speak out, is expected to lean in favor of protecting the river. Again, another example, where there is massive felling of indigenous trees or deforestation, an informed decision must consider that women use such indigenous trees as medicine for themselves and everybody in the household, and for cooking as well. Trees are also a good source of oxygen. A good judgment must consider and express, and that is where I just want to pause there and draw an emphasis on that one. A good judgment must not only consider, but it must also express an alternative means or measure to the use of firewood for purposes of making fire. In other words, in ordering that deforestation must stop, then what is the substitute? For instance, newspaper and other discarded forms of paper may be recycled. I have here an example of recycled. You know, you don't need giant machines to recycle something. You can, through a simple procedure, and I'm saying that judgment which you are writing, you must be able to capture these alternative means. As you stop deforestation, which we need the forest, but you must also come up with an alternative substitute. How? And then you must embody that in the judgment. It must be clear. For instance, let me just give and I was assisted by women from Durban when I had visited there on a personal, taken a personal visit. And I came across, because I always, I like to encounter or to meet the grassroots level persons or people when I go to a country, every country. So while I was in Durban, I met these women and I visited their stalls, as we have stalls outside there, and I found something of this nature. And I asked, what is this? Then they informed me that this is firewood. How do you make this? You take your newspaper or that discarded paper. For instance, we are now going digital. We have virtual hearings. We no longer need hard copy files in our offices. So instead of taking those hard copy files, the volumes and volumes that we've been keeping over the ages, now that you are digital, you can take this and distribute it amongst the women rather than taking it to the incinerators. Now you take this paper, you immerse it in water, and then when it has absorbed all the water, then you wrinkle, squeeze it, remove the water as a ball like this, as I have done, and then you put it in the sun to dry. With this, ladies, my fellow judges, you can roast meat, cook. At home, there's a pumpkin which takes hours and hours to cook. You can cook and have a full meal for the family. I want to take a different perspective with your kind permission, Rapporteur Justice Salawada, in addressing the environment perspective. Often the English idiom, I think it exists even in our African setup, is that charity begins at home. Justice Dabuza has captured very well all the instances with the case studies that she has given us, but I will not go there because that has already been done. I don't want to repeat. I want to look at an environment which is often overlooked, and yet it is very critical to the health of a woman. And I say this because in February when I was in court, at home there was an unfortunate incident which was reported in the paper. I don't know whether it's true or not, but we decided to take some action, an affirmative action towards it. It was reported that there was a well-known man who was working for a parastatal. He died, and then the wife discovered that she had been divorced. And she came to court challenging that she was not aware of any, during the lifetime of the husband, of any divorce proceedings against her. So we decided to take an approach and that no, every divorce case will invite the parties, whether it is unopposed, will invite the parties to be in court to be present so that they become aware, just to safeguard the rights of the other parties as well. Now, then I was handling a simple divorce case it was uncontested. It involved a high-ranking police officer. You know how they have all these stars, badges, and they carry this black road and they walk. So I postponed the matter because she was not present in court to allow her opportunity to come, and when her divorce case was, being deliberated, she'll be there, or the divorce order, because it was uncontested, was, passed, she will be there. I postponed it, I think it was a Friday. I said I'll hear it on Wednesday, the following week. Then after Wednesday came, I dealt with the matter. And then when I went to my chambers, my clerk says, Judge, that police officer says that she did not sleep the minute the lawyer phoned and said, the judge wants you in court. I said, why didn't she sleep? She said she feared appearing in court. It was shocking to me because this was a police officer. I would have thought that she's in the system, in the justice system, criminal justice system. She must be used to the court's environment. This is the environment I want to talk about. How do we address or allay the fears that witnesses and litigants alike experience? Most of our jurisdictions are under a legal system which is procedural, adversarial in nature. Justice Nora van der Heever, Chief Justice Maya spoke about her this morning as one of the first women in South Africa to occupy the bench. She was also sitting in our jurisdiction in the appeal court. She had this to say, and I quote, "Cross-examination does not mean examining the witness crossly." In other words, this was a pregnant statement advocating that in a court setup, let us not, in fact, then our witnesses must be treated well, or whoever comes to our court. This is testimony that our courts tend to be unfriendly, frightening, intimidating, which may cause an unhealthy condition to the person. So how do we improve our environment? How do we improve our courts? And I have said there that it may cause palpitation, anxiety, other stress-related conditions, health conditions. These therefore create an unhealthy environment which is contrary to the spirit of Article 18 that we spoke about of the protocol, Maputo Protocol. How then do we align our adversarial system with Article 18? That is my next focus. As a short-term action, judges are expected to control the proceedings in their courts. The use of aggressive words or phrases such as "you are a liar" or "this is pure or green lies," as they often say, should be substituted with kind words, "you are mistaken," or "that is incorrect." Do we agree? Harsh voices must be toned down. Long and winding cross-examinations be equally guided. That's a short-term provision. I want to borrow from this example. We were once faced with a pandemic where children were sexually harassed during the HIV/AIDS pandemic. I think you recall that. Then we gathered our heads, We sat down, how can we address the plight of children? And we came out with children's friendly courts and the use of intermediaries. And my question is, can we create a setup that is user-friendly for women as well as a long-term action? Or adopt a much holistic approach by ensuring that matters commence at conciliation and mediation before, and then litigation be the last. These are just examples that I'm giving for which are supposed to address. And therefore, by taking this, rather than, cases starting at litigation, we first call the parties to chambers, see if we can reach some agreement, have the parties conciliate and mediate, and then if it fails, then go to litigation. That is that is my approach in creating an friendly environment in the court setup so that we do not harass, witnesses, particularly women. Because most of the time they come to court as victims. They have already repeated their story before the investigator, before the doctor. Now they must repeat the same version before us. So can we take this?
One more round of applause, please, my ladies. I found that this presentation not only thought-provoking, but moving. I'm not sure whether you'll agree with me, but my lady's presentation on unpacking Articles 18 and 19 of the MOP Protocol, but also giving us real-life experiences, in my view, is moving and tells us a lot. I know the day is far advanced, almost 6 o'clock, but we still have an obligation to open the floor for intervention, questions, anything to add to the presentations. The floor is open. Yes, I can see a hand up, just that, my lady, you're very far. Perhaps you could just introduce yourself and take the floor.
My name is Mary Joaku. I am from Cape Town, Mitchell's Plain. My question is to the Honorable Judge Dlamini, in as far as creating a friendly environment in court. How do you strike the balance of creating that friendly environment in court as well as still maintaining the decorum of the court? I am saying this because in Mitchell's Plain, for instance, in trying to do exactly that, you end up finding the accused persons or the witnesses calling you Mama Africa instead of your worship, instead of the magistrate. And you try to speak with the parties, the representatives of or the representative of the accused or the witness. Please, your client can't call me Mama Africa. You address me as a magistrate or you address me as your worship, but they will continue to say Mama Africa, and you don't know where does that come from. Perhaps because of the afro, I don't know. But
Thank you very much, my lady. You answered the question.
Yes, thank you. Can I leave it to the floor? Who is willing to answer, to address that question? Cost decorum, at the same time creating a friendly environment.
Go ahead. Yes, go ahead. Go ahead, yes. Is there someone on the floor to hand over the mic? Yes, my lady, you can take the floor after.
Thank you very much for the presentation. I'll attempt the Mama Africa. However, I had my own issues. I think the challenge that we usually have in our courtrooms, especially when we're dealing with our people who are coming from the rural areas, they have their own euphemisms on how they address people when they want to show respect. Now, these are people who have come from a cultural context, and now we bring them into the courtroom, which is a new environment altogether. They are overwhelmed with their issue. Now they're also overwhelmed with the decorum of the court. Perhaps when we're dealing with such issues, we have to appreciate where we're coming from, how our people address us, the euphemisms that they use, and then bear with them. When they call me Mama Africa, I know that they want to call me lady. So perhaps in my ethnic background, where I am coming from, when they want to say lady, they will say mama. So we should be able to hear them that in this particular context, what they mean is they want to show us the respect that they have been told that you have to respect that woman who is at that particular table. Appreciate it and be content that I have been properly addressed in this particular issue. That would be my contribution.
Thank
However,
you.
my ladies, I had my own issue. I don't know whether I can proceed. I want to know from my ladies, how do you deal with, Lady Dlamini, you mentioned the providing an alternate remedy. Now, how do you balance that in a courtroom where you have already talked about it's an adversarial system where we deal with pleadings? Now, that adversarial remedy that you're talking about has not been included in the pleading. If you come up with a judgment in that context, won't that be a ground of appeal? That is my interpretation.
Otherwise, I'll give my lady, Justice Kudirat, the floor, but then we will come back to your question. Yes, my lady.
Thank you very much, Justice Kekereekun, Federal Republic of Nigeria. The first one is a comment on conducive atmosphere in court. I think what is important, especially when you are dealing with vulnerable persons, is to perhaps lay the ground rules, so to say, so that when you start to adjudicate, you can, as a preface, say that I appreciate you are not used to the court system and so on, and so we are going to handle the matter in a particular way. The important thing is fairness, so that neither side feels that there is a bias in favor of another side. So I think that is what is important. Because perception is really important in the way we handle our cases. So if the perception of anybody watching the proceedings, they can see that you are not trying to assist one side or the other, you are just trying to provide a level playing field and to be more explanatory and understanding, so that you are not, sometimes, a witness is asked a question, may not respond the way you expect, but it's because of either lack of understanding or fear. So you can be a bit more patient with such a witness, but not in a way that gives the impression that you are favoring one party or you are taking over the proceedings. Then there was another interesting observation made by the last speaker about alternative routes to litigation. And I want to say that in Nigeria, we have something called the multi-door courthouse. Now, the concept of multi-door courthouse is that when there is a dispute, there are different doors that you can open before the final door of litigation. So those different doors could be conciliation, mediation, arbitration, and so on. So what we have done is that we have what is called court-connected ADR. whereby there's a system attached to the court that requires parties to first explore any of these alternative doors before going to litigation. Now, if you have filed a matter in court, there's a process whereby those cases can be filtered to see which ones are amenable to some of these alternatives. And there's a procedure for referring those cases. So it's incorporated in the rules of court. There's a procedure for referring those cases. There's even something called the settlement week in some courts, where they take a week to go through cases and see which ones can be referred to alternative doors. Many times the cases are resolved through that process. And in some of the places where it works also, you have a different judge dealing with that aspect. So when the matter comes to court, there's a settlement of issues. That settlement of issues stage is handled by a different judge. If the issues are settled and it is decided that this is a matter that should go to one of the alternative doors, it is referred there. If it comes back for any reason, it will be a different judge that hears the matter. But this is incorporated in the rules of court. And we are also encouraging mediation and arbitration even at the appellate level. So the Court of Appeal has a mediation center, and presently even the Supreme Court is in the process of setting up a mediation center. So this is something that allows a less formal approach to the resolution of disputes. Thank you.
Very much, my lady, Honorable Justice Kudirat. I think that answer should have answered, my lady, your question. It didn't. You still want the answer from Justice Lamini?
Yes, my lady. I think he was talking about, she has been talking about alternative dispute resolution mechanisms within the court. However, my address to Justice Lamini is about providing an alternative remedy to the challenge that is before the court, like how she introduced that new firewood. So my query was about, you know how strictly our courts are applying rules of procedure, and that the remedies have to be sought. The relief that you are looking for should be in the pleadings. If it is not in the pleading, you cannot claim it. Now the court introduces something that is very strange to the sitting. And this is a woman who is represented by legal aid. On the other side, we have that seasoned lawyer. How do you deal with that setting? How do you introduce something that is outside the pleadings and advise that in the judgment that this is what you should have done?
I get your question. You know, as judges, we are called to be proactive. And so long as we develop the law for the good, I doubt if there's any penalty for that, or your judgment will be set aside. Like the example, because it's very critical that we create an eco-friendly environment. So like the example that I gave, if there is a case on the felling of the trees and there's an order by, an application by maybe a community saying we are against this. All I'm saying, grant them the order, but also tell them, because maybe they want to go and cut and get firewood, then tell them, no, don't minimize your access for firewood because there is an alternative means of making firewood which is available. We must be active, develop the law, not necessarily legislate, but come up with something that will benefit the parties, the society at large. Rather than to be so formal and say, because the rules are taking these directions, we can't
pay a blind eye, to something that is, being havoc in the environment. Because the spirit of this article, Protocol 18, is that it is our duty, and these protocols have been said to be legally binding upon us, everybody. So what is it? What role can we play? So long as we are taking the right direction that will benefit eco-friendly judgments, I think they'll be welcomed and applauded.
Thank you very much, my lady. Are there any other interventions on the floor? Yes, ma'am. Yes, my lady. Can you just hold on, just for my lady to come?
I just want to say something on that Mama Africa. I think the delegates have responded very well. But I just want to say something. When someone is in court and is addressing you, you can, as a judge, easily tell that he's being contemptuous or he's being genuine. He can say Mama, but you can tell that this is the way of respect. And another one can use the same word, Mama, and you can see that this one is being contemptuous or insultive, if I can put it that way. Then you can deal with that particular individual. So the environment, it depends on how it is said.
Thank you very much. We'll take one more intervention from Judge. If you can kindly introduce yourself and take the floor.
Ok, merci beaucoup pour la parole.
Thank you very much for the floor. My name is Madame Martha Audio. I am judge at the Constitutional Court of the Democratic Republic of Congo. My intervention is in fact just an observation. I noticed that 20 years after the Maputo Protocol was adopted and enacted, the major challenge remains its transformation into a living jurisprudence able to sustainably influence the judiciary and also transmit whatever we have acquired to the future generations. So in this sense, it is the judiciary power that has to give this commitment all its power. The judiciary power must guarantee access to women to environmental justice. For instance, by ordering the ceasing of polluting activities. I come from the Democratic Republic of Congo, where we have a lot of women who are living in areas where mines are exploited, artisanal exploitation, industrial exploitation that is degrading the land, contaminating rivers and destroying forests that they depend upon for their services. Those women that are cultivating those lands are directly exposed to heavy metals and chemicals, and the judiciary power must also impose preventive measures. For instance, by checking the conformity of mining project or industrial project, by checking the existence of environmental pact and also sanitary norms that are affecting women. Maybe they can suspend a project that is polluting, exposing pregnant women to toxic substances. Now, these women are generally far from courts, and there are pressures that are exercised upon them. So they don't necessarily have that easy access. I'm not saying all of them, but I'm talking about the case of a minority who are unable easily to access the justice, go to court because of procedures and also the luxury that constitute paying a judge sometimes or a lawyer. Sometimes they are intimidated, violated, and the judge who is supposed to help, but unfortunately the judge is not available. Now, the judge unfortunately cannot be accessed or seized. So that is why I understand that jurisprudence is not very developed. There are cases of violations, but we don't have jurisprudence. Now, I'm suggesting that the Maputo Protocol may be promulgated, adopted, but we need a great awareness. That is what we are doing in the Association of Magistrate Women in DRC. Not long time ago, we did the work of creating awareness of this protocol. Now, to get hold of the judge, victims have a problem. Sometimes they also have the pressure of the economical power. People who are coming to exploit my minerals. It's just not anyone. I saw on TV they showed a maize farm where they needed to create a road that goes directly to a place where an industrialist has a mining ground. So the road must go through that maize farm that is destroyed. Now I see women running behind those tractors. It was very difficult and very hard to see. Now, that case, did we see those people running behind the tractors because they were busy destroying the maize farm? Could the judge be accessed? Public ministry, are they able to transmit these cases in justice? Now, these are the different questions that I ask myself that I have not seen the jurisprudence. Now, my colleague and I, during this work, yesterday, I believe we asked the question to the area where there is a big concentration of mining, and we asked the magistrate who is there. Do you have a jurisprudence to give us when it comes to the environmental right? Now we received the answer just now. I'm going to give him the floor to tell us what they got as an answer when it comes to jurisprudence. I would like to thank you. May I speak?
Out of time, I'm sure your intervention would have been very interesting, but I'm being cautioned that time is completely off. So my apologies for that. And with that, I would like us to thank the two speakers we've had this evening, but also to thank all the interventions and all the questions that were asked. One round of applause, please. I will now hand you over back to the Director of Programs to conclude the evening.
Which one? This is, no, that's my program. Thank you. Thank you. It has been a long day. I'm sure you'll agree with me. I've been given 25 minutes for the closing remarks. I promise you I'll do it in 5 minutes, if you bear with me. Wow. Now I'm struggling with my, and AI is tomorrow. I don't know why is it doing this to me. Give me the other one. Okay. As we bring this important gathering to a close today, we do so with deepened sense of purpose and responsibility. During the opening session, we are reminded at the outset, through the reflections of the Speaker of Parliament, that the struggle for women's rights in South Africa and across our continent has been organized, courageous, and intentional. From the call of nothing about us, without us, to the entrenchment of equality clause in our Constitution, these principles underscore the importance of women in the judiciary. We extend our appreciation to all the speakers and participants for their thoughtful presentations, reflections, and active engagement throughout the day. The experiences shared and the spirit of collaboration have enriched the discussions and will meaningfully inform our actions going forward. Our Minister Kubai, reminded us that even the most progressive legal framework will not transform society unless it is implemented. The first session regarding the enduring scourge of gender-based violence is a painful reminder that our task is to ensure that the law is not distant from the daily experiences of women and girls. Vice President, Lady Justice Shafika Bensawala reminded us that rights are protected when institutions give them force. The African Court's jurisprudence, including the case APDF versus Mali and Glory, Hussein and versus Benin, demonstrates the living power of the Maputo Protocol. We are also reminded by the Secretary General of the CCJA that one of the clearest expressions of that progress is the growing presence of women in the judiciary. As the Chief Justice said, that is Chief Justice Maya, the presence of women on the bench enriches judicial reasoning, deepens the court's understanding of lived realities, and strengthens the legitimacy of justice. When we began our plenary session, we also had experiences from the various countries where emphasis was placed on constitutional reforms, strengthening protections against all forms of violence against women, including psychological, economic, and digital violence, alongside a shift towards state-supported protection mechanisms and victim support services. This was followed by insights from Zimbabwe, focusing on domestic violence legislation, constitutional jurisprudence on child marriage, victim-friendly justice systems, and the persistent structural and social-cultural barriers that affect enforcement. From South Africa, the discussion highlighted the judiciary's transformative constitutional role in developing substantive equality through case law, addressing sexual violence, customary marriage regime, and gender-based discrimination, as well as institutional reforms such as South Africa's sexual harassment policy within the judiciary itself. We had comparative perspectives on marriage systems with inputs on how countries, including Mozambique, Gabon, Nigeria, and Zimbabwe manage plural legal systems and the resulting tensions between civil, customary, and religious regimes. The next session focused on economic justice, where we reflected on how constitutional equality provisions and international regional instruments require not only formal rights, but real access to economic participation, to property and labor protections. The speakers highlighted judicial interpretation as central to addressing structural dependency. We also heard from Angola on the gap between constitutional guarantees and lived experience, particularly in rural contexts where poverty, illiteracy, and customary practices continue to undermine women's autonomy, alongside the need for deeper community-level engagement beyond formal legal structures. Gabon also shared important reforms on property ownership, inheritance equality, housing policies, and women's economic empowerment initiatives, while noting ongoing cultural and implementation challenges. In the last session, which was very informative, I must say, where we even struggled to get speakers, but I'm not surprised. I'm not surprised because Justice Dambuza, she really prepared a well-researched document. Maybe that's why people didn't want to be with you. This session underscored the women's right to live in a healthy and sustainable environment as protected by Article 18 of the Maputo Protocol. The deliberations emphasized that environmental harm is not gender neutral, as women, children, and persons with disabilities and low-income communities are often disproportionately affected by pollution, exclusion from natural resources, and unsustainable development decisions. Drawing on constitutional and statutory frameworks across African jurisdictions, the sessions highlighted the need for courts to balance development with environmental protection. What is now outstanding from us for today's session are the resolutions that we are supposed to come up with. We have a proposal from our side. If you allow us, we work with the technical team overnight to draft something which can be presented tomorrow morning as a way of proposals from today's session. You see, I promised you 5 minutes. That's it. So we're in the process of finalizing that. So if you allow us, we'll do that. And before we start with the first session tomorrow morning, we'll present the draft resolution for adoption. And once you say adopted, then we'll be covered. That is the end of the session today. Thank you very much for being such a wonderful audience. Thank you very much for putting up with me. And we will see you tomorrow morning. Those who still have the energy and are still keen on going out, because we had promised you that you will be taken to, is it the square? What do you call it? Mandela Square? Mandela Square. The bus will leave at 6:45, because now it's 6:15. So you can take your bags to your rooms, get comfortable shoes, and be ready downstairs, and the bus will take you. Thank you very much. Thank you.